My name is Dylan Hightower, Hightower.
Investigator Hightower, good afternoon.
Good afternoon, sir.
Where are you employed, sir?
I currently work for the 14th Circuit Solicitor's Office as an investigator. I also supervise the Criminal Intelligence Unit within our office.
All right, well, what is the 14th Circuit Solicitor's Office?
The District Attorney of the 14th Circuit, which is comprised of 5 counties, Allendale, Beaufort, Colleton, Hampton, and Jasper counties. Our office handles all general sessions-related criminal offenses in court.
All right. And specifically your role as an investigator, what are your duties at the 14th Circuit Solicitor's Office?
Yes, sir. My duties are to prepare cases for trial, locate and identify witnesses, interview witnesses, obtain any additional evidence that may be needed prior to trial. We also prepare witness testimony for all of our potential witnesses for all of our trials. Also, outside of preparing cases for trial, I assist with local, state, and federal law enforcement agencies with active and criminal investigations.
Okay. And can you just briefly describe your background in law enforcement that led to your employment at the 14th Circuit Solicitor's Office?
Yes, so in 2010, I graduated from the University of South Carolina in Columbia with a Bachelor of Arts degree in sociology. Soon thereafter, a criminal intelligence position became available within the 14th Circuit Solicitor's Office, to which I then applied and accepted. Initially, when I first was hired, I attended a 4-week on-the-job training at the South Carolina Law Enforcement Division in the Fusion Center for Criminal Intelligence Analysis School. Afterward, I attended the PennLink Call Analysis Training Center there in Columbia as well. In 2013, I became a Class 1 certified law enforcement officer. In 2014, I attended the ETS Fundamentals of Call Detail Record Analysis in Pinehurst, North Carolina. In 2015, I attended and became a Sistine Secure View cellular forensics operator to obtain the evidence from a specific device or telephone, cellular telephone. In 2016, if I may refer to my notes?
Yes.
Timing. Later on in 2015, I attended a course, Gladiator Cellular Forensics course, where we learned about ESPA and GAR. ESPA stands for Enterprise Sensor Processing and Analytics. GAR stands for Gladiator Autonomous Receiver. Essentially, that class taught us to use specific devices and software to identify digital footprints of cellular towers within a specific area. In 2017, I attended a operator course for Black Bag Mobilize, which is a forensic tool to extract data off of a cellular telephone. In 2018, I attended the FBI CAST. CAST stands for Cellular Analysis Survey Team, on a class involving historical cell site analysis, which identifies tower activity, tower orientation, sector information of incoming and outgoing calls on a specific telephone number.
And Investigator Hatter, I'm going to stop you there. So as part of your job as investigator at 14th Circuit, your role is to help with cell records and cell tower information, correct?
Yes, sir, among other things.
And you've also had training on downloading and doing extracts from phones as well, correct?
I do, yes, sir.
Okay. All right. Is it unusual for you to respond to murder scenes in the 14th Circuit?
No, sir, not at all.
And you've personally met the defendant in this case, Mr. Alex Murdaugh, is that correct?
Yes, sir, I did.
All right. And does Mr. Alex Murdaugh, or at least at one point, have an association with the 14th Circuit Solicitor's Office?
Yes, sir, he did.
What was that association?
He was identified as a volunteer solicitor within our office.
All right. And when you say assistant solicitor, what does an assistant solicitor do?
They prosecute cases in General Sessions Court.
And you've, in your role, you've participated in a number of trials before, correct?
I have. I've been doing this for approximately coming up on 12 and a half years.
Okay. Have you had an opportunity to participate in any trials with the defendant, Richard or Alexander Murdaugh?
Yes, sir, there was one.
All right. And approximately when was that?
Probably 2015, 2016. It was a murder case out of Hampton County.
And what role did Mr. Alexander Murdaugh fill in that case?
He was essentially one of the prosecutors on the case. his father, Randolph Murdaugh, was technically the lead on the case and who I spoke with and met with prior to my testimony in the trial.
Okay. All right. Let's move forward to June 8th of 2021. You recall that day, sir?
Yes, sir, I do.
And did you have an occasion to respond to 4147 Moselle Road here in Colleton County?
Yes, sir, I did.
All right. And briefly explain how you became involved and why you responded out there on that day.
So that morning, multiple phone calls were crossing through multiple employees throughout our office regarding the incident that occurred. We being myself, two other investigators, my solicitor and my deputy solicitor, traveled to Sled Low Country here in Walterboro and attended a briefing involving all the law enforcement agencies responsible for the investigation. During that briefing, we learned more about the particulars of what had occurred, and then afterward, we had all traveled together in multiple vehicles to 4147 Moselle Road.
Okay. So yourself and several other 14th Circuit investigators responded, correct?
Yes, sir. I drove with one other investigator riding with me. One additional investigator met us there. Captain Ryan Neal with the South Carolina Law Enforcement Division was in the vehicle with Solicitor Stone and Deputy Solicitor Thornton.
And now, you just testified that it's not unusual for you yourself to respond to murder scenes, correct?
No, sir. And all of the murder cases that I've been involved with and any type of criminal proceeding, probably 95% of those scenes I've actually gone to.
Okay. And was it unusual for the solicitor to respond to a scene that quickly after an incident in your experience?
No, sir, not at all. Again, we, as a staff involved with the prosecution team, we had always traveled to a crime scene if we go to a courtroom.
All right. And just so it's clear, I don't know if you said it yet, but who is the solicitor of the 14th Circuit?
Solicitor is Duffy Stone.
And he'd be your direct boss, right?
I go through the Deputy Solicitor Sean Thornton, but
He'd be the ultimate boss.
the ultimate boss is Solicitor Stone, yes, sir.
All right. And once you got to the scene, what did you do?
Once we arrived on scene, we met with Captain Ryan Neal, kind of all in a group. Captain Neal then walked around the scene and kind of noted different points of view, different pieces of the crime scene had already been relinquished at that point by the crime scene agents. There was no crime scene tape up. It was wide open. There are multiple members of the law firm there, other SLED agents as well. We had all kind of walked around the scene, around the barn, around the kennels, identified the points of interest of where each of the bodies were with Paul and Maggie, and then kind of circulated around the property and got a better visual of what all actually occurred.
Okay. And while you're there, did you bring any equipment with you to help aid in the investigation?
Yes, sir, I did.
What did you bring?
Our 14th Circuit Solicitor's Office drone.
Okay. I'm going to show you some pictures. Let's see, they are marked Exhibit 242, 241, 240, 239, 237. Get these papers apart. 238. Do you recognize those pictures, sir?
Yes, sir, I do.
All right. And what are those pictures?
This is drone imagery of the scene right around the kennels and the general vicinity around the kennels.
And that was from a drone you operated?
Yes, sir, it is.
And about what time do you recall that you took those pictures and what day?
It was on June 8th of 2021 between 1:30 and 2:30 p.m.
Okay.
afternoon.
Take those back from me. Look at them anymore. This time State Murdaugh offered exhibits 242, 241, 240, 237, 238, and 239.
They're admitted without objection.
Okay. I'll need the Elmo, please. Okay, can you see this picture on your screen, Investigator Hightower?
Yes, sir, I can.
All right, and what is this image of?
So this is closest, kind of in the direction of the house, looking back towards the hangar area, as well as the dog kennels off to your right. My vehicle is right dead center in the picture, and then other SLED agents' vehicles were over on the left.
Okay. And I'm going to ask you to step down real quick to point out a couple things, if you don't mind. All right, and you might have to step over those boxes, but can you point out, from what you were told when you were on scene, approximately where Paul Murdaugh's body was found on that picture? However you need to.
Paul's body was right here near the dog kennels.
Okay, and where was Maggie's body?
She would have been right under this area over here, just on the corner around the edge.
And you testified by the time you got to the scene, the slate crime scene, you cleared it, and it departed, correct?
Yes, sir.
And when you say, you can take a seat again. When you say that the crime scene had cleared, what does that mean to you?
It was no longer an active crime scene. Once the crime scene tape is removed, it's no longer active.
So other individuals could walk and view the crime scene at that point?
Yes, sir, that is correct.
All right, and that was Exhibit 240. And I'm going to show you Exhibit 241. And that's the same general area, a little bit closer on where Maggie and Paul's body were, correct?
Yes, sir, that is correct.
Okay. All right, and now I'm going to show 242. All right, and that's a little bit lower angle, looking at the same area where Maggie and Paul's body were, correct?
Yes, sir, that is correct.
Okay. All right. And I'm going to show you Exhibit 239. Okay. What is this? What is this angle? What is it looking at? And in fact, if you want to step down again and point to the jury, that glare is pretty bad. Yeah, that's better. Okay, so at the top of this picture, in kind of the center, what is that?
So this here is the residence of 4147 Moselle Road. That's the actual residence. This is the field between the residence and the kennels. Again, the kennels, the edge of the kennels is right there. You can see the top of the hangar there as well. So this is a direction looking directly over the hangar, pointing directly back towards the residence.
All right. And I'm going to ask you to sit down a second, but I want to call your attention to this line of trees right here. You see that, sir?
Yes, sir, I do.
All right. In this picture, you can take a seat. This picture was taken again when?
These were taken on the afternoon of June 8th, 2021.
And we see some pine trees kind of running diagonally between the kennels and the house, correct?
Yes, sir, you do.
And you were out there at the scene personally, correct?
I was.
And from the best of your recollection, can you remember the approximate height of most of these trees at that time?
I would approximate probably 6, 7, maybe 8 feet on certain ones. But you did get a clear channel, a clear view back towards the residence.
Okay. And you've been out there more recently, haven't you?
Yes, sir, I have.
And did you notice any differences with those trees, at least present day, compared to June of 2021?
Yes, sir. It's much more overgrown than what it looks like in that picture.
Have those trees grown higher?
Much higher, yes, sir.
All right, I'm going to show you, this is going to be Exhibit 238. And this is approximately the same angle, correct?
The same angle, just the drone shifted backwards a little bit so you could actually see the full hangar, the full kennels,
Okay.
as well as the residents.
All right. And finally, I'm going to show you Exhibit 237. All right. And what angle is this in relation to the others?
So the idea behind this was to identify both driveways accessing the residence as well as accessing the barn area. So this is further back, kind of closest to the field area, looking back towards the hangar, the dog kennels, and the two driveways that you could travel or arrive onto the property.
And this gives a good angle of those trees we were just discussing to show how closely they're spaced, correct?
Yes, sir, that is correct.
Okay. Let's step back a little bit chronologically, a little earlier in the day of June 8th, 2021 for you. While you're at the scene, did Maggie's cell phone come up in conversation?
Yes, sir, it did.
All right. Describe the context of that. How did it come up, and who was there when it came up?
It was during the general overview of the scene. We started asking questions about pieces of physical evidence that might have been identified. I learned at that time that Paul's phone was found on him, and Maggie's phone was not located anywhere near the scene during scene processing. So therefore, I explored other options to try and identify where her phone may be.
And you testified a while ago. You've got pretty extensive training and experience dealing with cell phones, correct?
Yes, sir. Every case, I would say 95% of all of our cases we put to a courtroom involve all forms of digital forensics, cell phone extractions, cell phone records, things of that nature. It's a part of our everyday life.
So with that background, when you learned Maggie's phone was missing, did you have any ideas?
I did, yes, sir.
What idea did you have?
Knowing that they were the Murdaughs were a close-knit family, I figured one of the family members might have had her direct location on Find My iPhone, knowing that they all utilized iPhones.
And did you communicate that idea to anybody?
Yes, sir, I did. I spoke with John Marvin Murdaugh on scene.
All right. And what did he do in reaction to your suggestion?
He believed that one of the family members did have access to Maggie Murdaugh's phone location via Find My iPhone. He left for a few minutes, short minutes, and came back to me with a cell phone believed to be Buster Murdaugh's phone.
You're not 100% positive whose phone?
Not
it was?
100% positive.
All right. And what did you do once this phone was handed to you by John Marvin?
I took possession of the phone, obviously looked at the virtual map, walked in the direction of where I believed it to be to see if it might be in the general vicinity of where we were around the dog kennels. As I walked probably 30, 40 yards, I realized I was much further away than I originally anticipated. So I then went back to my vehicle. I got in with John Marvin. I had possession of the phone the entire time. Two of our other investigators, Solicitor JoJo Woodward and Investigator Donnie Hutto, rode with me back towards the general area of where the device was showing.
Okay. And so you had this family phone the entire time, correct?
Yes, sir, I did.
And you were tracking to where Maggie's phone exactly was?
I was driving and looking down at the phone, making sure I was going in the proper direction.
Approximately how far did you drive?
About a half a mile from the entrance to the barns,
Okay.
the driveway to the barns.
I'm going to show you what's been marked as Exhibit 227. Do you recognize that?
Yes, sir, I do.
All right. And what is that?
That's an overview from Google Maps that shows both the residence as well as the general location of where I ultimately located Maggie Murdaugh's phone along the edge of Moselle Road.
And you prepared that?
I
to show
did.
the location?
Yes, sir.
All right. And state moves 227 new evidence. Can you see that on your screen, Investigator Hightower?
Yes, sir, I can.
All right, we're going to ask you to step down one more time. All right. On this overview, can you point out where the residence is for 4147 Moselle?
The residence is here. You can see the driveway here as well. And then the kennels are up here.
Okay. And there's a marker on there, correct, that says general location of phone?
Yes, sir, that'd be right here.
All right. And that's where you found Maggie Murdaugh's phone, correct?
Yeah, so I was walking, when I was trying to get a better idea of where the phone actually was, I was walking up and down the driveway here to the kennels, obviously looking down at the phone, trying to identify the general location. Once I started to realize the phone was much further away, that's when I jumped into my vehicle. I turned and went southeast of the residence area. Once I got to this specific area where the field kind of opened up, I started getting closer and closer to the blue dot that you would see on Find My iPhone. Once I got closer and closer, we all got out on foot and walked the property to identify where that phone was.
Okay. And you can take a seat. And I'm going to hand you Exhibit 236, 235, 234, 233, 232, 231, 230, 229, and 228. Do you recognize any of those?
Yes, sir, I do.
All right, and what are those?
These are photographs that I took of Maggie Murdaugh's phone as it was laying in the brushed area or leaved area closer to Moselle Road, about 15, 20 feet away from Moselle Road.
And did you ever personally pick up Maggie's phone?
I never touched the phone. Once I identified the location of where the phone was, I contacted Captain Ryan Neal with South Carolina Law Enforcement Division. He sent a team with Special Agent Katie McAllister and Special Agent Jeff Croft to take possession of the device.
So when you took these pictures, Maggie's phone had not been touched, correct?
It has not been touched. No,
All
sir.
right. At this time, state's going to move exhibits 236, 235, 233, 231, 228, 227, 230, 232, and 234 into evidence.
No objection.
They're admitted without objection.
Okay, I'm going to show you first Exhibit 230. All right, and in the center of this, I see two orange flags. Do you see those?
Yes, sir, I do.
What are those orange flags?
So once I located the device, I found some standard landscape flags laying around. I then obtained those, walked over towards where the phone actually was, put one towards the phone and one kind of where you could see from the roadway as the SLED agents were responding to collect it.
Okay, so where was Maggie's phone in relation to these two orange flags again?
So it'd be the furthest one away. This is just a point of view from the street looking back towards where the phone was.
Okay. And we see, looks like pavement in the foreground, is that correct?
Yes, sir. That is Moselle Road.
And so that represents the edge of the road, correct?
That is correct, yes, sir.
And just so it's clear, is this the north side of the road or south side of the road?
This would be,
Well, let's go back to the map. Let's go back to exhibit 227. So is this represent north-south is up and down on this map you prepared?
Yes, sir, it does.
Okay, all right. So was the phone found on the right side of Moselle Road on this picture or the left side?
It would be on the right side
Okay.
during from this angle.
Okay, I'm going to show you exhibit 234. And do you recognize what's in that picture?
Yes, sir, I do.
All right, and right in the center of that picture, what is that?
That is the Apple iPhone that actually had a camouflage case with an orange tint to it, and there was standing water on top of the screen.
Okay. And I see a little black area if you look up and left of the phone in the center of the picture there. Do you know what that was, or was that anything significant?
I don't believe it was anything significant. From what I recall, it might have been a bottle or something of that nature.
Okay. I'm going to show now exhibit 231. Okay. And I believe in the center of this picture, towards the bottom, what is that?
That is the cell phone identified as Maggie Murdaugh's phone.
And we see a orange flag just a little bit in front of it. Is that correct?
Yes, sir, that is correct.
Okay. And is that the orange flag you placed?
It is.
All right. And then in the distance, I see a line, a white line. It doesn't show very clear on the Elmo. But what is that? And I can bring the picture to you if you need.
Well, I could explain what this picture is of, looking back towards, because based off the glare, I can't even see the roadway.
Right. I'll show you. Okay. What? On this this far line here, what is that?
This back here?
In front of that.
Okay.
that
This
white.
is 40. This is Moselle Road
Okay.
here. This is just on the opposite side of the cell phone, looking back towards the field area, the trees for line of reference to identify where it was actually located.
Okay. All right. And can you approximate the distance from the road that you found this phone?
I did not step it off or measure it, but I would say between 15 and 20 feet.
Okay. Okay. I'll show you exhibit. Excuse me. Some water. All right. We are looking at exhibit 228. All right. Describe what's in this picture, please.
That is just a more close-up picture of the Apple iPhone recovered from the leaves.
And do I see something on the screen of that phone?
Yes, sir. It's standing water, believed to be from the moisture from the night before.
And that screen, is that facing up or facing down?
The screen is facing up.
All right, I'll show you exhibit 235. All right. And what's in this picture?
It's just the opposite angle on the other side of the phone, more of a close-up of the iPhone.
And you can see those water droplets on the phone.
Yes, sir.
All right. And I see some sort of line on top of the phone. Can you tell what that is?
Appears to be some sort of plant or
Okay. And finally, 236. What is in this picture?
again, more of a close-up from the top of the phone looking down.
Okay. All right, and this is exhibit 233. All right, what is in it? Describe this picture.
So the reason behind this is to obviously identify the location of where the device was. I had walked out to Moselle Road, gotten to the center of the roadway, and taken a picture of the trees in the field directly on the opposite side of the road of where the phone was found.
Okay. All right, and this is exhibit 232. Describe this picture, please.
This is me standing in the same location as the previous picture. This is me just turning right towards the residence to show the pitch in the road as well as the start or the break of the field off to the left.
So you're standing basically across the road from where Maggie's phone was found, correct?
That is correct. It'll be directly to my right in this picture.
And facing down that road, what's that way?
That's back towards the residence and the kennels.
And whose vehicle? Do you recall whose vehicle is in that picture?
That was Captain Ryan Niels.
Okay. Finally, Exhibit 229. All right. And what's this picture?
That is a close-up of the back of the picture, or back of the iPhone. That's Special Agent Katie McAllister that has possession of it. At that point in time, we had put it in airplane mode and sealed it into an evidence bag.
All right. Now, you did not physically pick the phone up, correct?
I never once touched the phone, no, sir.
You observed it being picked up, correct?
I did, yes, sir.
And, all right. And did you have any further to do with Maggie's phone after it was collected?
I was provided the extraction once that was completed.
Okay.
But yes, nothing further with the actual device.
Okay. Now it's from Lieutenant Dove.
That is correct, yes, sir.
Okay. Let's go forward to the day of June 10th, which was 2 days after you found Maggie's phone. Is that correct?
Yes, sir, that is correct.
All right. And did you have reason to respond back out to Moselle on that day?
It was not Moselle,
Okay.
but I believe it was John Marvin's hunting property.
Okay. All right. You responded to John Marvin's hunting property, and why did you go there on that day, June 10th?
I was requested to extract cellular phones from Alex Murdaugh, Randy Murdaugh, John Marvin Murdaugh, and Buster Murdaugh, while they're all being questioned by SLED agents.
All right. To your knowledge, did all those individuals provide consent for that
Yes, sir, they
search?
did, as well as their passcodes.
Okay. All right. So how many phones did you download again? I'm sorry.
During that time frame, I had extracted 3 total phones. There towards the end, once the interviews were being concluded, a phone call was made to multiple family members explaining Randolph's condition, and they all had to leave and go back into Alameda.
Okay.
I was only able to extract 3 phones at that time.
And whose phones were that?
It would have
was
been
3?
Alex, Randy's, and Buster Murdaugh's phone.
All right. And just generally speaking, why did you download? Why were you needed to download his phones on that day? What was the purpose?
I was tasked by multiple SLED agents to assist them while they were conducting all their interviews to extract the contents of their phone to see if there might be any evidence of the murders in any of their phones.
And was it unusual for SLED in this area to request your assistance with some cell phone evidence?
No, sir, not at all.
Okay. All right. So you downloaded those 3 phones. This jury has heard testimony about different types of extractions. What type of extraction did you do on June 10th with, let's focus on Alex's phone. What type of extraction did you do?
The initial extraction was an advanced logical that I had done there on scene at the hunting property.
How long do you recall approximately that logical extraction took?
Advanced logical was basically just a surface area of the phone, identifying the call logs, incoming and outgoing phone calls, text messages, any emails, general location information. You won't always get a whole lot of location information, but ideally to get a pretty good idea as to what's happening on that phone during that time frame.
And just time-wise, I know every phone's different, but do you recall approximately how long it took to download Alex's phone?
I would say between 30 minutes and an hour. None of the phones took any longer than an hour to conduct an advanced logical. Full file system takes much longer.
So between the 3 phones you successfully downloaded today, it took you between, in total, an hour and a half to 3 hours approximately, you would say?
Yes, sir.
Okay. This jury's heard about full file system and physical extractions before. You have that capability, correct?
Yes, sir, I do.
All right. But you did not perform that on those 3 phones on June 10th, correct?
That is correct.
And just again, generally speaking, knowing every phone's different, how much longer does a physical extraction take than a logical extraction?
It depends on the size of the phone. Obviously, phones these days are getting much larger. Depending on the size of those phones, depending on how long a full file system extraction would actually take. It could be hours, it could be days. It just kind of depends.
Okay. And did you feel like you had hours and hours and days to download those phones?
No, sir, I did not.
Because what did you do after you were done extracting them?
I supplied each of their phones back to them, obviously because of the issues dealing with Mr. Randolph at that time.
And you felt some pressure because of the health issues of Mr. Randolph to return their phones to him so they could take care of family business?
Yes, sir, that is correct.
Okay. All right. And so you said a minute ago, so all you removed from these phones was that surface layer of information, correct? Is that what you?
Yes, sir.
All right. And that surface information includes text and call logs, pictures and videos and that sort of thing, correct?
Yes, sir, it does.
And you said sometimes you get some location data, but not always, correct?
That is correct, yes, sir.
All right. Now, in relation to Alex's phone, was there a concern about his status as an attorney on that?
Yes, sir, there was.
All right. And that phone could potentially contain privileged information, correct?
Yes, sir, that is correct.
All right. So you did the raw download, logical download, and did you initially look at anything on Alex's phone on June 10th?
I did not. I was, once the extraction was completed, I obtained the UFDX file, which is the raw file for a Celebrite file. I then transferred that electronically over to Sergeant Paul McManigal with the Charleston County Sheriff's Office, who also serves in the United States Secret Service Task Force, the Cyber Crime Task Force. I also did that with Randy Murdaugh's phone as well. So I sent him 2 of the UFDX raw files from Celebrite for him to dump into what's called Physical Analyzer to extract the data. At that time, a Tain attorney was assigned from the Ninth Circuit Solicitor's Office. She had met with Sergeant McManigal and gone over all of the attorney-client privilege information, and I was provided a working copy of Alex Murdaugh's phone from Paul McManigal a few days after that.
Okay. But just so it's clear, you said she was from the Ninth Circuit?
That is correct, yes, sir.
And that's a totally separate office from your circuit, correct?
Yes, sir, it is.
All right. Once you received this redacted logical phone extraction from Sergeant McManigal, what did you do next?
I opened it in what's called Celebrite Reader, which is an executable file that allows you to go in and view the contents of the phone. It's essentially a dashboard that allows you to maneuver around the device itself in a more readable format and identify incoming, outgoing calls, read text messages, any type of emails, photographs, videos, or anything that might be in that person's camera roll.
And in the course of your assistance to this investigation, did you acquire any other records to assist you in looking through these phones?
Yes, sir, I did.
What did you acquire?
I was supplied with all of the call detail records from Verizon for all of the parties that we had obtained information on or obtained a search warrant on to identify ideally location information. What I like to do in my cases, if we have a phone extraction as well as phone records, I like to compare the two and identify any discrepancies or any issues that might occur. But the call detail records allow you to obtain location information if you don't get it from the Celebrite extraction.
Okay. And so you obtained via search warrant or assisted obtaining via search warrant cell records for Mr. Alex Murdaugh and some other individuals, correct?
Yes, sir, I did.
And those records have been entered into evidence as 268, correct?
I believe so, yes, sir.
All right. And you said, you just testified that you took those cell phone records, which, to remind a jury, that's information that's stored by who?
By Verizon, in this case Verizon, but yes.
By the cell company, correct?
Yes, sir.
All right. And you compared it to the information you found on these phones, correct?
I did, yes, sir.
And specifically, with Alex's phone, what did you discover when you're comparing these phone records to the phone itself, the call log?
Once I started, I essentially built a digital timeline of all forms of digital evidence that we had during that time frame, and it was kind of a working copy. During that time frame, I compared the call logs from the extraction or from the actual device to the phone logs that I saw in the call detail records provided from Verizon. On the date in question, on June 7th, I only saw 2 FaceTime calls on the phone extraction, and I saw a series of around 73 phone calls on the Verizon call detail record.
Okay. And what did that tell you when you saw that missing information?
It could be a multitude of things. They were either removed by the user or the one responsible for using the device. It could have overlapped from the call log history. It could have been a series of things, but I just wanted to make sure that I identified the phone numbers that were in communication during that time frame, and the lack of that information on the actual
And
phone.
you just said it could have overlapped in that. What does that mean?
Over time, your call log obviously gets historically just kind of removes itself from the call log history on your actual device. It's nearly impossible, or actually I know of no way to delete any phone calls that you might have made that had processed through the network, or in this case, Verizon.
So there's no way for a user to delete records from Verizon, correct?
That is correct, yes, sir.
But you know, in your investigation of his phone, of Alex's phone, I mean, is that what happened? Did his call log just simply overlap? Were you able to determine that?
I was not able to determine it because it was an advanced logical, so I wasn't able to recover any deleted items during that time frame.
So you didn't recover any deleted artifacts of the phone call?
That is correct. No, sir, I did
When I
not.
say deleted artifacts, what does that mean?
Anything that was manually deleted from the device itself.
All right. And there's sometimes a trace left in memory when something is deleted, correct?
Yes, sir, that is
But a
correct.
logical extraction is not going to find that, correct?
No, sir.
Okay. All right. But did you, in your review of the call logs, did you discover whether sometime prior to the June 7th, that there were still calls in those logs?
Yes, sir, there was.
All right. And so is this a case where simply the calls just simply overlapped and the oldest went out as the new calls were made?
It's possible.
Well, if there's a gap, you just testified there were phone calls.
Yes, Your Honor, we.
Did you just testify that there were phone calls from prior to June 7th still remaining on that phone?
FaceTime calls, yes, sir.
Okay.
On the call log on the phone extraction. The report that I was provided, because it was a working copy, was from June 1st to June 10th.
Okay. All right. But there were FaceTime calls prior to that, correct?
Yes, sir, that is correct.
And when a user accesses just the phone itself and they look at a call log, will that display both calls made over Verizon? It will display calls made over the Verizon network, the call log?
Yes, sir.
It will-
Anything that connected to the network.
All right. And will it display FaceTime calls as well?
It would, yes, sir.
All right. And you found FaceTime calls from prior to June 7th, correct?
Yes, sir, I did.
All right. And, but as far as you could tell, as far as calls themselves, when did you start seeing call records start?
Right around the morning, late morning, early afternoon of June 8th, 2021.
Okay. All right. And is there, other than this overlapping situation, is there any other way that you're aware of that could have removed that gap in phone call logs?
If the user went in and manually removed it themselves.
But there's no other automatic process other than what we've already discussed.
No, sir.
And did you discuss with Sergeant McManigal whether his process in redacting certain things, did that process remove any call logs from that download?
Yes, sir, I did review with Sergeant McManigal, and obviously we had discussed the results that were provided to me, and we both agreed on the same opinion.
All right. And that Sergeant McManigal did not remove those records, correct?
That is correct.
All right. For this witness.
Yes, sir.
Understand you, and it's sort of an alien concept to me, Swister's office going to murder scenes. You go to a bunch of murder scenes?
Yes, sir. Among my other duties, I am involved with the ATF. I'm a task force officer with the ATF, the Bureau of Alcohol, Tobacco, and Firearms out of Charleston. So I do some proactive roles there, as well as reactive roles in investigating crimes that will ultimately be my case anyways and come into a courtroom.
If they arrest somebody.
If they arrest somebody, in some cases when no arrests are made, yes, sir.
When they're what?
In some cases when no arrests are made, I would still arrive or respond to the crime scene.
And you took Solicitor Duffy Stone with you, the chief prosecutor for the circuit, right?
We rode in separate vehicles, but yes, he was along with me, yes.
And I think I saw somewhere in the evidence, he actually took photographs that morning, did he not?
Yes, sir, he did.
Is that usual? That the solicitor go around doing evidentiary photos?
Not at all. With the way his mind works, he goes in and he thinks of every idea possible of what could possibly be an issue later on down the road if he prosecutes a case, and he wants to make sure that's all documented in his own book.
And so if he takes a picture and wants to use it in the prosecution, does he introduce it, authenticate it, and take the stand, authenticate it, and then come back down, or he ask himself questions? How does
No,
that
sir,
work?
he does not.
Okay. Let me move on to something a little more productive. You went to a briefing that morning, you said, when you got there.
Yes, sir, I did at
And
Slugboat Country.
who was the briefing by?
There were probably 30, 40 plus investigators, officers, but multiple, essentially SLED, Colleton County Sheriff's Office, a few Walterboro Police Department, I believe, and a few from my office.
I guess when I think of a briefing, I think of someone standing in front of the room and saying, here's what we got. Was there one person speaking?
There were multiple people speaking, but that was the whole idea, was to get a better grasp as to what had occurred the night before.
But I guess, so who spoke?
Multiple agents, multiple responding officers from the sheriff's office. I don't recall exactly who spoke.
How long did the briefing take?
Approximately 45 minutes, if I had to guess.
And you have no specific memory of any specific person saying any specific thing?
There were multiple people speaking, going over
So the answer is no.
I do not recall exact people's names and exactly what they said. No, sir.
Do you recall any one person that spoke?
I know Captain Ryan Neal spoke.
Okay.
Special Agent David Owen spoke. I believe Captain Jason Chapman with the Colleton County Sheriff's Office spoke. There was a multitude of people talking about different things that they had seen the night before or the morning of.
Had they indicated to you, any one of those people, that they had a suspect, that they were focused on any particular person?
No, sir.
Did they have an explanation for anything? I mean, at that point, was there some theory about what happened?
At that point in time, we were trying to identify all the physical pieces of evidence as well as obtain and preserve all digital pieces of evidence to make sure we had a strong enough case moving
Were
forward.
you aware that the Colleton County Sheriff's Department had issued a statement to the public saying there's nothing to be afraid of? People, this is not something that you should view as a threat.
No, sir. I'm not aware of that media release.
You did not hear anything like that morning. Well, let me ask you this. If you had an active shooter at large, would police take any proactive steps? Would they put up roadblocks, or would they put out a statement, look, we've got two people brutally murdered, and we don't know who did it, so keep your doors locked. Be careful about if you see somebody in the woods or walking along the road. I mean, you see these, unfortunately, much too often these days, but did you?
Your Honor, object. Mr. Harpillion seems to be testifying. Are we getting to a question?
Yeah, the question is, did you all do any? Did you see any, not you, did you see any evidence of that or hear any evidence of that morning?
Not that I recall, no, sir.
Okay. Not that I recall means,
I don't remember. I wasn't focused on what was on the media.
okay.
at that time.
But did you see any roadblocks?
No, sir, I did not.
Did you see anybody searching fields or the woods around the place?
There were multiple tasks that were provided to each investigator during the briefing, and multiple people went out and did their own thing of whatever they were tasked with.
Do you remember what those tasks were?
Following up with potential witnesses.
Right, but I'm talking about, did you see anybody going through the woods armed looking for a person or persons?
No, sir, I did not.
Okay, you didn't see any roadblocks, you didn't see any active search for a suspect in the sense of somebody was armed, well, they knew at that point there were spent shotgun shells and spent blackout casings, right? You'd heard that?
Yes, sir.
So somebody, either two people or one person with two guns, was at large at that point as far as y'all were concerned.
Yes, sir. I mean, ideally.
Okay. Did any of those agents indicate during your briefing that they felt that there was somebody at large that posed a danger to the community? Did you hear any of that?
I don't believe so.
Okay. So, let me find the critical element here. So, When you got there the next morning, there were no bodies, there was no physical evidence there. It was after all that had been removed.
All the bodies have been removed. All of the trash from the crime scene agents were stacked up. You could see some blood stains in the ground, and as well as some body matter over towards the dog kennels.
And I'm not going to belabor this and put these pictures up, but you had a drone up, right?
Yes, sir, I did.
And did you ever go up to the residence?
I did not go all the way to the residence. No, sir.
Okay, and I don't see any pictures taken from the kennels that you took or under your direction up towards the residence. Are there any?
From the kennels looking back towards the residence?
I mean, but looking from the murder scene back up towards the residence.
Yes, sir, I did take those photographs.
That was during the day, not the night, correct?
Yes, sir, that is correct.
Okay, so you don't know what somebody from the house could see at night looking down towards the kennel?
No, sir.
Okay, I just want to make sure it was clear that you weren't testifying somebody up at the house at night would have an unobstructed view of where the bodies were found or the front of the kennels. You're not testifying to that, are you?
No, sir, I'm not.
Okay. So let's talk a little bit about the phone. I thought I had the exhibit number of the phone down. You don't know it off the top of your head, do you? Anybody? What? Oh, up there. Okay. It's I think it's 204, which I would find in that box. While he's looking for that, if you continue to look for that, I'd appreciate it. Let me ask you some questions. You indicated the distance from the shoulder to the road, shoulder of the road to the phone was about 15 to 20 feet?
Yes, sir.
Okay. And you took a number, did you take those pictures of the phone?
Yes, sir, I did.
Was there any other person there taking pictures other than you?
I was the only one with a camera, so I took the photographs.
Okay. And were you there the entire time until the phone was removed?
Yes, sir, I was. I stayed right next to the phone until Special Agent Jeff Croft and Special Agent Katie McAllister arrived on scene. They took possession of the cellular phone and placed it into an evidence bag.
Okay, and during that period of time, did any sort of forensic team come up and measure how far the phone was from the shoulder of the road?
No, sir, they did not.
Did anyone attempt to come up with a specific location for that phone in terms of measurements, a forensic assessment of where that phone was?
No, sir.
And what are those exhibits that were just introduced? Yes. So, for the record, it states exhibit number 204. It looks like the case and the phone are separated. So this is the actual phone, is that correct?
Based off of this case, I remember seeing a camo and an orange labeled case.
If somebody's written on this, that's not you.
No, sir, it's
Because
not.
you never touched the phone.
I did not, no, sir.
All right. And this is a SIM card. What is a SIM card?
It's stored within the device. It's a secondary form of storage for a cellular device.
And so if you, anything you do on the device is stored on the SIM code?
Not necessarily, no, sir.
What's stored on here?
It depends on the network, depending on the provider that you utilize. Different providers offer different resources through your SIM card. But
Did you ever examine the SIM card?
I never examined anything on that phone, no, sir.
You did a download, but you didn't examine.
Not on Maggie's.
Oh, you didn't do Maggie's phone?
That's
stand
correct, yes,
corrected. Okay, but somebody could look at the SIM card and get perhaps information that's not on the phone?
Yeah, in some scenarios, yes, sir.
Okay. Now, what I'm going to try to figure out, by looking at these pictures while I hold this, I'll bring this phone back in just a minute. Is I want to. Is it still on? Okay, how about get that so we can see it?
I have it also on.
Well, let me, it's just easier for me to put this down there. So that is exhibit number, sorry,
228.
228. How about I push that again? And that's what you saw when you came on the phone, correct?
Yes, sir, that is.
And I think we see, and I think he pointed it out a little while ago, there's pieces of straw and other things around it, right?
Yes, sir.
So you would agree with me, if someone had carefully walked over and placed this phone, there wouldn't be anything above it, because everything that straw would be under it, correct?
It's possible, yes, sir.
Okay. And in addition to that, did anybody forensically check the area around it to see if there were footprints?
No, sir. I mean, it was heavily treed, heavily wooded, a lot of leaves. There, you could not see any foot impressions around that phone.
Okay. A lot of leaves.
Yes, sir.
And so is this sitting, I mean, when it's sitting there with the straw over it, is it sitting flat on the ground? Is it tilted? Is it, what do you remember? Or if you don't?
There was a slight tilt, probably centimeters, nothing major, nothing out of the ordinary around the phone, no holes, no pushed up leaves or anything like that.
So you couldn't, I mean, strike that. Okay, let's look at, let me make sure I get the right one. Let's put this one on there. Okay, so again, that's another picture taken by you of the same phone in the same location, correct?
Yes, sir, it is.
And it's heavily wooded in that area, correct?
Right on the edge, yes, sir.
And it's almost a thicket where you found this, right? There are bushes around it?
No bushes. There were a lot of trees.
A lot of trees and underbrush.
And underbrush, yes, sir.
Okay. So nobody actually took measurements of where this was found. No one actually measured from the road, nor did they measure. I mean, there's no way to figure out exactly. If you had to go back today and find the spot, could you find it? The exact spot?
Within a couple of feet, yes, sir, I probably could, based off the angles of photographs that were originally taken.
Okay. But you couldn't give us the exact spot, right?
I couldn't give you an exact step from the actual device to where Moselle Road was.
Okay, this is exhibit number 232. And that's a vehicle on the same side of the road as where the phone was found. Is that correct?
Yes, sir, that is correct.
And so that car window that we see in this photo, the driver's side, you want to finish that? The driver's side window would be 15 to 20 feet from where that phone was, correct?
I would add a few more feet just because of the roadway. Yes, sir.
Okay, you add, so 28 to 30, 25 to 30 feet? Fair?
That would be fair, yes, sir.
But nobody measured it, so we don't.
No one measured it, no, sir.
Okay. And so if that car was going towards Almeda, you know where I'm talking about?
Yes, sir, I do.
It would be on the other side of the road, right?
On the right lane of the road, yes.
I mean, it'd be on the right, but here it's improperly parked, correct?
Sure.
I mean, the driver's window is, I mean, if there's a car coming the other way, they'd head on, would they not?
That is, yes.
Okay, that's the point.
You
I'm
would be
making.
operating the vehicle on the right side of the road, or left in that image.
Okay, so if someone were driving towards Almeda on this road, and they wanted to get rid of that phone, they would either have to throw it 40 feet out the driver's side window or pull over as this car has and throw it out, correct?
It's a series of things that could have happened, the reasons why that phone got there, but it's possible.
Well, it's just assume with me for a second that they want to get rid of that phone by throwing it out the window. They could either throw it from their lane of traffic if they're going towards Elmina, or they can pull over like that and throw it out. It'd be easier, when I say easier, it'd be a much tougher toss that far in from if they never left their lane of traffic, correct?
Guess it depends on who's throwing it. There's a multitude of things.
Me, it'd be me, and I don't throw very well.
No. Well, I do, so I could 100% make that throw.
You could throw it from, okay, so you wouldn't even have to change lanes, you just throw it out the window.
Yes, sir, 100%.
And you would throw it overhanded or underhanded?
I'd throw it sideways, flick it.
Sideways, okay. Okay. So there's no way to tell, we don't know if somebody threw it out. Out of the driver's side window. Are you throwing it with your left hand or right hand out the driver's side window? I mean, you said you could toss it pretty far.
I would throw it with my left hand from the driver's side and could easily land it to where it actually was found and located in the woods.
But you right-handed or left-handed?
I'm right-handed, yes, sir.
But you could still throw it with your left hand with that much power?
Yes, sir, 100%.
Okay. Now, let me ask you this. When you found it, you wanted to put it in, or somebody with you wanted to put it in airplane mode, right?
Yes, sir, I wanted it to be placed in airplane mode to preserve its contents.
Because in airplane mode, less chance of any data being overridden, right?
That is correct, yes, sir.
Now, that doesn't prevent all data from being overridden, but most data, correct?
A lot, 99%, I would say, to prevent any issue with the phone.
Does it prevent GPS data from being overridden?
From another device,
No. I mean, just
internally, just
yes.
automatically deleting
Internally?
itself?
Yes.
I've never seen that happen.
Okay. But you don't know whether it's going to happen or not.
Presumably, no.
So you needed to put it in airplane mode to prevent anything from being overwritten, right?
Any outside tampering from another device that had access to its iCloud
And
information?
you told the agents with you, I want to put it in airplane mode, right?
Yes, sir, I did.
And to do that, you have to be able to open it. You need the passcode.
No, sir, you do not.
Don't?
Not on an iPhone, no, sir.
You can put it on airplane mode without
Yes, sir.
opening it.
You
Well,
just-
but what did you need the passcode for? Because somebody called and got the passcode.
We did not get the passcode at that point in time. No one knew we had located the phone, so there's no reason to ask for a passcode if we didn't have it.
Let the court's indulgence for a moment.
Later on, we received the passcode, but not at that point.
When did you receive it?
I was not present. I did not analyze the device, so
Was it at the scene or was it somewhere else?
I do not recall. I was not there.
So no one told you that Alex Murdaugh provided Maggie's?
No, sir. No one told me that.
Now, if someone had the passcode, they could go in that phone and eliminate, delete text messages, phone calls, just about any piece of data that's captured there, correct? Even apps, you can delete those, correct?
They could have, but once the full file system extraction was done by Lieutenant Britt Dove,
No, you misunderstand my question, I'm sorry. If you had that phone, and obviously Maggie Murdaugh had been murdered, somebody threw it on the side of the road, and during that period of time after her murder, before it was thrown on the side of the road, if you had the passcode, right?
yes,
Open
sir.
it, Without the passcode, typically you can't open it, correct?
No, sir.
You agree with me?
I do, yes, sir.
Okay, I'm sorry. So if you had that passcode, you could open it, delete photos, delete phone messages, delete texts, delete whatever you want, correct?
Yes, sir.
Okay. And when you found that phone, it was locked?
Yes, sir, it was.
Okay. And was there any evidence that you saw that anything had been deleted from that phone in any of your, after your download, extraction?
Again, I did not download or extract the contents of the device. The only thing that I saw was the home screen and made sure that the airplane mode was applied at that point, and then it was placed into an evidence bag. We never got past that lock screen or home screen that allows us to turn on airplane mode. Obviously, the device was on because we were able to locate it through Find My iPhone, and the battery level was significantly low.
Was significantly low?
Yes, sir, it was.
Okay. Beg the court's indulgence.
Anything further?
We talked about the call logs, and so you downloaded Alex's phone on June 10th, correct?
Yes, sir, that is correct.
3 days after the murder, correct?
Yes, sir.
And
Not responsive to my cross-examination. I never mentioned Alex phone, not once.
Response?
I'll proceed, Your Honor. At some point, after you were involved in this investigation, you're informed by Solicitor Stone. You were informed by the Solicitor Stone to stop, correct?
Yes, sir, it was.
And you recall approximately when Solicitor Stone.
Objection, Your Honor, again, not in response to a matter raised by me on cross.
Sustain the objection.
And Mr. Harpootlian asked about the crime scene in its state when you got out there, correct?
Yes, sir, he did.
All right. Did you notice any vandalism?
No, sir, not at all.
Did you notice? Were you informed, or did you notice anything missing?
Objection, Your Honor. How do you know it was missing?
Maybe the witness knows. Overruled.
I knew Maggie's phone was missing, and that's it.
Okay. But you noticed any vandalism or anything?
No, sir, not at all.
Okay. All right. And when it comes to Maggie's phone, at least her model, are you aware whether that can be placed in airplane mode without the unlock code being entered while the phone is locked?
You can place that phone in airplane mode while it's locked, yes.
Okay. So you don't need a code to just simply put it in airplane mode, correct?
No, sir.
All right. And did anybody manipulate any data on that phone in your presence?
No, sir, not at all.
Okay. Nothing further from the state.
You may step down. We'll take a 10-minute break, ladies and gentlemen. Please do not discuss the case. Finish their own rise.
You may now be seated.
You may bring the jury. Thank you. You may call your next witness.
The state calls Katie McAllister.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about the judge of court in this trial shall be the truth? So help you God.
I do.
Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Katie McAllister, McCallister.
Good afternoon, Agent McAllister.
Hello.
Could you please tell the jury where you work?
I work for the South Carolina Law Enforcement Division, more commonly known as SLED.
And how long have you worked for SLED?
10 years.
And what is your position there?
I'm a senior special agent in the Low Country Region Investigative Services.
And were you a senior special agent back on June 7th of 2021?
I was just a regular special agent then.
Did you have a chance to respond to Moselle Road in that capacity as a SLED agent?
I did.
Can you tell us when you responded out there?
I was told late on the night of June 7th to be at the office on June 8th. I was given some assignments, and then I responded to the actual property around lunchtime on June the 8th, 2021.
So June the 8th, the day after the murders took place.
Yes.
And what did you do when you got out there?
Myself and Special Agent Croft were almost to the house. There were several people in the roadway. It appeared to be blocked, so we stopped and got out.
Did you, what were those people up to?
There had been a phone located on the side of the road.
Okay. And whose phone was that?
It was Maggie Murdaugh's cell phone.
And can you tell us about your involvement in the collection of Maggie Murdaugh's cell phone?
Yes, so once we got out of the car, I had gloves. Captain Neal retrieved the phone from where it was laying. I was standing right beside him when he got a phone call. He handed me the phone with my gloved hands. I held the phone for Investigator Hightower to take a picture of it. The phone call was Captain Neal receiving the passcode. He asked me to confirm it. I typed it in. We confirmed that it was the right passcode. I locked the phone. At that point, Investigator Hightower asked me to put it in airplane mode, which I did.
And so what was the point of you putting the passcode into that phone?
To confirm that the passcode we were given matched the actual phone that we had.
To confirm that was Maggie Murdaugh's phone?
Yes.
Okay. And when you unlocked that phone, did you delete any calls?
I did not.
Did you delete any text messages?
I did not.
Did you alter any data in that phone?
I did not.
You locked that phone back immediately?
Yeah, as soon as it opened, the screen clears to show that that is the right passcode, I immediately locked it back.
And then what happened to the phone as far as you know?
Captain Neal, who was standing right beside me, took the phone back.
All right, let's move on. What else did you do?
So once I arrived on scene, myself along with Special Agent Croft were asked to go up to the main house to do a search of the property, or of the home.
Did you have a search warrant?
There was a search warrant, yes.
Was that search warrant executed?
It was not.
Why not?
At the time of my arrival, multiple family, close friends were at the house. Rather than executing the search warrant and displacing all of those people, we asked for consent and we were given it.
And were a lot of people at that residence at the time?
There were.
You could give us kind of a rough estimate of the amount of people that were there.
I would say maybe 20 or 25 people were in the home.
And you didn't want to have to ask all those people to leave?
Some of them were very upset, and we thought it was better to simply ask for consent.
Tell us what you found in the search of the house.
So upon consent, I walked through the residence. I was looking for weapons and ammunition and observant to anything else that may have been of value. I found nothing, and once I came back downstairs to the gun room, Agent Croft had located several items of interest, some weapons and some ammunition. He and I collected those. I completed a property receipt.
Let's go back to your search a little bit. When you walked through the house, were you alone?
I was not.
Who was with you?
I believe it was John Marvin Murdaugh and Lee Cope.
And who were those people?
John Marvin Murdaugh is Alex Murdaugh's brother. Lee Cope is an attorney from their law firm.
And what rooms of the house did you search?
All of them.
And these John Marvin and Lee Cope were with you when you went in every room?
They were.
Did you search any other places?
We searched bathrooms, tubs. There were several attic-type spaces where different holiday decorations were stored. We looked in there, or I looked in there, and we didn't locate anything of value.
Did you look anywhere that you thought there could be a long gun?
Yes.
Did you observe any bloody clothing when you were searching the residence?
I did not.
And you said you were observant?
I was.
You mentioned that Agent Croft had collected some weapons and some ammunition.
He did.
Would that be the 3 shotguns, a Mossberg, a Browning, and a Benelli Super Eagle, along with a .300 blackout rifle?
Yes.
And then some various ammunition?
Yes.
Okay, and what did you do with those items?
So we gathered them together. I filled out the property receipt. We took them back to the SLED office here in Walterboro, where we met with the crime scene agent, Agent Worley, and I receipted those items to her.
So Agent Worley took custody of those items.
She did.
Do you recall at some point speaking or being present at an interview with Buster Murdaugh?
I was.
And was any evidence collected during that interview?
Yes, we asked him for consent to do a buccal swab and also consent to look at his cell phone.
I'm going to show you this case exhibit 217. If you could tell me what that exhibit appears to be.
This appears to be the buccal swab from Richard Alexander Buster Murdaugh Jr., collected June 10th, 2021 at 3:26 p.m.
Now, did you collect this buccal swab?
I did not.
Who collected it?
Lieutenant Charles Gint with SLED.
Okay. Were you present when it was collected?
I was.
How did Lieutenant Gint collect this swab?
A buccal swab is just 2 cotton swabs. He opened them from the packaging, swabbed his mouth, sealed them back up, placed them in the envelope you see there, sealed it, initialed it, and dated it.
And he would have sealed that up so it was not tampered with. Is that correct?
Yes.
Your Honor, at this time I move State's Exhibit 217 into evidence.
No objection.
Admitted without objection.
Your Honor, I have no further questions for this witness at this time.
Cross-examination.
Please, Your Honor.
Yes, sir.
Let me get. You were present when the phone, Maggie's phone, was recovered, correct?
Yes, sir, I was.
Matter of fact, that, when we look at one of these pictures, a rubber glove, that's your hand, correct?
Yes, sir, it is.
And are you aware when you got that call with the passcode that had been gotten by John Marvin? Was John Marvin down there with you when you found the phone?
I don't recall seeing him there, no, sir.
Okay. Are you aware that that passcode came from Alex Murdaugh?
No, sir, I was not aware of that.
And who gave it to you?
Captain Neal.
Okay. Now, you searched the house on the morning of, was it the morning of the 8th?
It would have been the afternoon.
Okay. And you went through the entire house?
Yes, sir.
How many bedrooms in that house? Do you know? How many bathrooms in that house?
3 or 4, I don't recall the exact
Okay,
number.
but you went through every one of them.
Yes, sir.
And you looked at the tub, you looked at the showers, right?
Yes, sir.
What were you looking for?
Ammunition, weapons.
Blood?
If it was there, I was observant. We were looking for anything at that point.
Right. So when you look at the drain in a shower, if somebody's recently showered off blood, you would expect to see some trace evidence there, would you not?
I don't know that I'm qualified to answer that.
Do you know whether there are trace evidence forensics people that actually go in and swab those, right?
There are, yes, sir.
Were they there?
No, sir.
Did anyone ever ask them to come that you know of?
Not that I'm aware
Do you
of,
know
no,
whether
sir.
any of those showers or tubs were in any way swabbed or checked for blood or tissue or any DNA, anything that would indicate somebody had washed off evidence of a crime?
Nothing that I'm aware of.
Okay. But you, apparently you were the only one to do this, correct?
Yes, sir.
The only person that actually looked at the showers and the tubs, you eyeballed them, right?
I did.
You're the only person who SLED had examined the showers and tubs. And you're telling this jury you saw no evidence of blood, tissue, or anything that would indicate somebody had showered or washed off or bathed to remove evidence of a crime from them. Is that what you're telling us?
Yes, sir. There was nothing visible to me.
Okay. And you were the only one asked to do that by SLED?
As far as I'm aware, yes, sir.
Did you search the bedrooms?
I did.
You find any clothes anywhere? Shirt, pants, shoes that would indicate?
Objection, Your Honor. Could we ask one question at a time, please?
Well, I'm just including a class. Rather than asking it individually, I apologize. I can do it individually. Take a little longer. Thank you. Any clothes, shoes, any evidence of clothing that would have blood on it or indicate it had blood on it or tissue, anything that you saw in any of the bedrooms. How many bedrooms?
Several.
Several. You looked at all of them?
Yes, sir, I did.
Looked under the beds?
I did.
In the closets?
I did.
See any evidence of any clothes that had been involved in any sort of altercation that had left blood or tissue or brains? You see anything like that in any one of those rooms?
No, sir, I didn't find anything like that.
Beg the court's indulgence. Thank you. No further questions.
Any redirect?
No further state, Your Honor.
Thank you. You may step down. Ladies and gentlemen, we're going to have you leave for the day and to return tomorrow at 11:30 will be our start time tomorrow. 11:30, so you get a few extra hours today and tomorrow. Please remember not to discuss the case, to be exposed to any information concerning the case. And we will see you tomorrow if you'll go to the jury room. Be seated. Mr. Waters, we will continue with the 404 witnesses.
Yes, sir, Your Honor. I might have miscalculated by about 30 minutes, so I apologize. The witness is close by. If you'll give me one moment, please.
He does that.
Yeah, we'll be at ease for a few minutes.
Yes, sir. The state calls Michael Gunn for the in-camera hearing.
Left hand on the Bible. Do you affirm the testimony about to give before in this trial shall be the truth, so help you God?
Yes, ma'am.
Thank you. Speak loudly. Take a seat in the witness stand. State your whole name. Spell your last name for the record.
Yes, ma'am. Michael Gunn. Last name is Gunn.
All right, Mr. Gunn, this is obviously an in-camera hearing to determine the admissibility of some of the testimony. Do you understand that?
Yes, sir.
All right, and so I'm not going to go into all the background and everything for purposes of this hearing, but just very quickly, where do you work?
I'm a principal at Ford's Consulting and also do some lobbying work for the South Carolina Association for Justice.
Okay, and just very quickly, tell us what Ford's Consulting is and what services it provides.
Ford's Consulting, we are a general insurance agency, but also offer financial services such as structured settlements, regular annuities, deferral of attorney's fees, trust. We do lien resolution, back office trust account reconciliation, all sorts of things for plaintiffs primarily and their families.
All right, and then if you could, just very quickly, just for the record, explain what a structure is and how that interfaces with plaintiffs' lawyers.
Sure. So a traditional structured settlement is between the parties, and that only means between the plaintiff and the defendant or their insurer. And so usually it was set up in the 80s. It was designed to help plaintiffs protect their money and to keep their money. And it can be earned tax-free. Interest grows on that tax-free. And it's a very good tool, especially for minor children, for those who are incapacitated, disabled. Because of that growth, it can provide a steady stream of income, hopefully for the rest of their lives. Yes, ma'am.
You're talking faster than I do, and that says something.
I've been accused of that before.
All right, I know you just ran over here, so let's take it down just a notch.
No worries.
All right, good deal. Okay, so pick it up from there. If you want.
So essentially, the structured settlement, though, would come primarily, usually, except in very small circumstances, would come from the defendant and or its insurer to fund the annuity for the client.
Okay. And so the idea is instead of getting a settlement in a lump sum, it's in an annuity, so they get regular payments over the course of the term of that annuity.
That is correct, yes, sir.
So explain to me just very quickly again for the record the concept of constructive receipt and how that affects structures that you may do for a plaintiff's attorney and their clients.
Sure. So constructive receipt by the IRS is deemed when the money arrives in the plaintiff's trust account. That would be considered they have received the funds, and therefore the ability to do a structure has been taken off the table. The only way that you could do a structure after that would be to return the funds to the defendant and or its insurer, and then therefore let the they would have to agree to play ball and redo all the documents because there's so much language that's included in the documents that specifies this.
All right, so the settlement can't go to the law firm and then to the annuity company. That will ruin the constructive receipt and ruin the tax advantages of that.
It is in very rare cases that we're able to do that.
But generally?
But generally speaking, correct.
All right, so generally your services that you provide are consulting to sort of match up the client with an annuity company, and then that money is going to, in the settlement or whatever it is, verdict is going to go from the defendant or the insurer that's paying whatever that is, that verdict or settlement, directly to that annuity company for the benefit of that client.
That is correct.
Can't go to the law firm, generally.
Generally speaking.
Okay. All right. How long have you been with Ford's Consulting doing this work?
It'll be 18 years this summer.
All right. And what's the actual full legal name of the entity that you are part of?
Ford's Consulting, LLC.
Okay. Over the course of your involvement with this business, have you gotten to know the defendant, Alex Murdaugh?
I have.
All right. And just very quickly, tell me the capacity in which you got to know him.
It bore from a professional relationship, doing work with the trial lawyers, conventions, CLEs, things of that nature, which ultimately turned into a friendship born out of business.
Okay. And when you say friendship, was it a close friendship or more like a business relationship type of friendship?
I would say a business relationship type of friendship, but one that you would text with and call on occasion and things.
Okay. Did you ever do any structures for any clients that were represented by Alex Murdaugh as a plaintiff's lawyer?
Yes, we did.
All right, and just roughly, you remember how many?
I would probably say around 5.
Did you ever, what's the last one you remember at least having some discussion with him about doing a structure?
The last one that I remember having discussion with, I believe, was the Dion Martin case.
Okay, and tell me about that. Did that ever come to fruition or not?
It did not.
All right, and tell me what you mean.
We sent over some quotes. We got some information back from the defendant. He sent us information, a signed option, which I would assume was Mr. Martin's. Sent some information back, and annuities, you have to understand, are priced on a daily market. Sometimes that rate is good for a week or two. I sent several emails back saying, hey, this rate is going to expire. We need to move forward. And ultimately, we ended up closing the case cash because we never got a response.
All right, when you say you sent emails asking for a response, who were you sending those to?
I was sending those to Mr. Murdaugh as well as his paralegal, Annette Griswold.
Okay. And so ultimately got no response, so you just closed the file without any services ultimately being provided by Forge Consulting LLC?
That is correct, yes, sir.
I'm going to show you very quickly what's been marked as Exhibit 321 for this in-camera hearing, and specifically direct your attention to the 5th page of this exhibit and just see if you recognize that. And then you can flip to the next couple of pages, please.
Yes, sir, I do.
All right, tell us what that is. Just kind of flip through first.
That's just it's just an annuitized payment stream showing you when the payments will be made.
Okay.
And what the amount is.
And that's kind of the market rate thing you were talking about?
Yes, sir. Yes,
All
sir.
right, and what are the next documents? Just in
The next page is a disclosure page where we list all our disclosures, and it appears to be had been signed by Dion Martin.
Okay, keep going. That's the only Forge-related documents you see?
Let's see, that's the only Forge-related documents I see, yes, sir.
All right, let me take that back.
Yep.
All right. Put those up on the screen real quick. All right, so that's sort of the annuity schedule, is that correct?
Yes, sir.
And then this is the disclosure page you were talking about?
Yes, sir.
And that is Forge-generated paperwork typically?
That is correct, yes.
But this particular structure was never done because you never got a response from Elkin?
No, sir.
Or his office, is that correct?
That is correct.
Yeah. Sirens pass. Are you aware generally of what people call the boat wreck case or the boat case as it relates to the defendant, Alex Murdaugh?
Generally, yes.
All right, and just without going into specific facts, generally what was your understanding of that?
There was a terrible accident that happened somewhere down in the low country involving Mr. Murdaugh's son and several others, and a young girl passed away.
Were you aware that his son had been charged in that particular case?
I was.
And were you aware that Alex Murdaugh had been sued in a civil matter relating to that case?
I believe I was made aware through the news, yes.
Did you ever have any conversation? Well, let me ask you this first. Is it possible for lawyers to structure fees? Not the client, but the lawyer, if they're going to get a big fee from a large recovery and they decide they want the protection of an annuity, can they do that?
Yes, they can.
All right. And how does that work? Kind of the same thing?
It's the exact same manner as if the client were to do it. The check would have to come from the insurance carrier and or the defendant to fund the structured settlement annuity for the lawyer for their fee.
Did you ever have any discussion with Alex Murdaugh, either before or after the boat case, about structuring any fees that he had received in the case?
We had general conversations about structuring fees, but it would be the same conversation I would have with any attorney, like how you would do it, how you would go about doing it, and how checks would need to be made payable, et cetera.
Did you ever have any specific discussion after the boat case about the boat case and him wanting to structure any fees?
Not that I recall.
I want to take you to September 2021. Did you, around that time, receive a call from Lee Cope?
I did.
All right. And what did Mr. Cope ask you?
He called and asked me if he could, in confidence, give me a list of cases and see if we had any files on them. I told him that'd be fine. I was standing in my driveway. I wrote them down, got back with him later that evening and let him know that we did not have any of those cases open.
Okay. He gave you a list of clients and asked if you had any structures open for those, or potential structures.
He had asked me if we had any files at all. Generally, what we will do is if an attorney calls, we will open the case immediately, just so we have a name associated with the attorney.
Okay. And so he gave you a list of names. Did any of those names have any files?
No.
All right. Did he ask you about any banking that Forge Consulting LLC did?
He did.
And what was his question to you?
He asked me if we banked with Bank of America.
And what was your response?
I told him that we had banked with Bank of America, but had not for the last 3 or 4 years.
So you did not have an active account with Bank of America
We did not, no.
in September of 2021?
No, sir.
Did you have any subsequent conversation with Mr. Cope about the issues that he had raised with you?
I did. He called me the following day as well, which I believe was a Thursday, with another list of cases.
All right. And what was his inquiry to you?
Same inquiry. This time, the only one that popped up was the one I mentioned earlier, which is the Dion Martin case.
All right. And your response was there was a file, but it was never completed?
There was a file, but it was never completed, and we closed it out.
Did you ask him at this point, or did what was going on, or why these inquiries were being made?
I did not.
Did you ultimately find out what was going on and why these inquiries were being made?
I found out on the Tuesday after Labor Day.
All right. And what did you find out?
I spoke with Lee Cope, and he told me that Alex had been using an account called Forge to process the checks.
Is that account that he had been using, is that a legitimate Forge Consulting account?
Absolutely not.
Did any of that money that went into that account go to legitimate Forge?
No, sir.
Did Forge Consulting have anything to do with that particular account?
No, sir.
Let me show you a couple things real quick. Show you what's been marked as Exhibit 335 to your testimony in this in-camera hearing, and just have you look at that. You look at the name on that particular account.
Yes, sir.
All right, what does that say?
Richard A. Murdaugh, sole proprietor, DBA Forge.
All right, and is that account a legitimate Forge account?
It is not a legitimate Forge Consulting account, no, sir.
Any money that went into that account, did it have any legitimate relationship to the services and business that y'all provide to claims attorneys?
No, sir, none at all.
Exhibit 328. You see that check right there?
I do.
Made out to Forge?
Yes, sir.
Did that come to any legitimate Forge account?
It did not.
Stand by for me 1 second. Your Honor, to save a little time, I believe defense is willing to concede that if we went through all these exhibits that we introduced with Ms. Seconder with all those checks made out to Forge from the PMPED trust account, for purposes of this hearing only, they will stipulate that none of those went to a legitimate Forge account and instead went to the Bank of America DBA, Richard Murdaugh DBA Forge account that he just testified is not a legitimate Forge account.
I want to be more careful with the words. We are not contesting that issue for purposes of this hearing. That's correct. I don't want anything coming back.
Accept that stipulation as well.
They're not contesting that these checks did, all went to this particular account and did not go to legitimate Forge. For purposes of this hearing alone, I think that's acceptable to the state, Your Honor.
Yes, sir.
All right. It's so stipulated.
Yeah, we're not contesting. That's
Yes, sir.
yes.
Not contesting. Just want to be real quick. 327, is that legit?
No, sir.
326, is that legit?
No, sir.
325, is that legit?
No, sir.
324, is that legit?
No, sir.
323, is that legit?
No, sir.
322, is that legit?
No, sir.
321, is that legit?
No, sir.
320, is that legit?
No, sir.
319, is that legit?
No, sir.
318, is that legit?
No, sir.
317, is that legit?
No, sir.
315, is that legit?
No, sir.
And finally, 311, is that legit?
No, sir.
And by asking you not legit, did you just look at the checks on those various exhibits?
I did.
And all the ones that had forged on them from a client trust account, those are not checks that went to any legitimate forged account, is that correct?
No, sir.
Is that correct?
That is correct, yes.
Thank you. Your Honor, I believe that's all the questions I have for this witness. I'm sorry, excuse me. Thank you. Just really quick, at any time, did you ever hand deliver any checks to Alex Murdaugh for forge-related business?
No, sir.
And would that work?
I would not be delivering any checks. The only time that I would ever deliver a check would be made out to someone other than Forge. You would never make a check payable to us.
But you never had any legitimate business where I was like, hey, I'm gonna be in town. I'll come by and pick up the annuity, the check for the annuity or anything.
No.
Nothing further for purposes of this hearing at this time, Your Honor.
Defense.
Very briefly, Your Honor. Good afternoon, Mr. Gunn.
Good afternoon.
Yeah, I am sure that your Forge Consulting LLC has done a full investigation into this matter.
Yes, sir, we have.
And in that investigation, did you find in any record of this account that Bank of America under Alex Murdaugh doing business as Forge, did you see the name Maggie Murdaugh or Paul Murdaugh as co-signatories to that account?
No, sir.
You seen any record, any document that Maggie Murdaugh or Paul Murdaugh had anything to do with this account?
No, sir.
Your company is an insurance agent. Did you ever sell any life insurance to Alex Murdaugh on the life of Maggie Murdaugh?
No, sir.
Did you ever sell any life insurance to Alex Murdaugh on the life of Paul Murdaugh?
No, sir.
All right, that's all I have, Your Honor.
Anything further?
Nothing to say, Your Honor.
You may call your next witness.
Your Honor, state calls Chris Wilson. I'm sorry, Your Honor, he's downstairs. We'll get him right away.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give before the next trial shall be the truth, so help you God? I do. Please see when you're at the stand. State your name again for the record. Spell your last name, please.
My name is James Christopher Wilson, Wilson. I go by Chris.
Mr. Wilson, you understand that we're here for an in-camera hearing to determine the admissibility of your testimony?
I do.
All right, and you're a lawyer, so you get that.
Yes, sir.
So I'm not going to go into everything that I might cover with you in a trial, but I do want to focus on particularly the Ferris case. You know which one I'm referring to?
Sure.
First of all, though, just very quickly, you're a lawyer, is that correct?
I am, since 1998.
1998. And describe very quickly your practice for the record.
Actually, since 1995. I've had my own practice since 1998. In the last 15 years, I've done primarily personal injury work, automobile accidents, people that are injured at work, practice type cases, those things.
And where do you normally practice? Where's your home base?
My only office is in Bamberg.
Do a lot of claims work?
That's all I do anymore. For the last 15 years, that's really all I do.
And do you know the defendant?
I do.
And when did you get to know the defendant?
I've known Alex since we were in high school. Bamberg and Hampton. I grew up in Bamberg, and they're only about 30 miles apart. And so I knew of Alex and had been around him some growing up. We had some mutual friends. I was a lot closer to some other guys in Hampton that I grew up playing golf and things like that with, but I would cross paths with Alex. Played on the same baseball team one summer, I think like our senior years in high school or somewhere around high school age. Didn't really keep in touch with him or cross paths with him until we ended up going to law school, and we started law school together at Carolina. 3 years there together at law school and lived together part of the time.
Did y'all become friends?
We did.
Become close friends?
Very close.
Best friends?
He was one of my best friends, yes. And I thought, he was, and I thought he felt the same way about me.
You feel that way now?
I don't know how I feel now, Mr. Waters.
Fair enough. Over the years, as you developed that close friendship with Alex, did y'all also have a professional relationship as well?
We did. When I finished law school, I went to work in Greenville for a judge for a year. Alex went to Beaufort to work with a law firm there. So we'd see each other, but it was more socially then. When I moved back to Bamberg to start practicing where I'd grown up, and he moved back to Hampton a couple years later, we started doing a little bit more work together, and we've done cases together really since 1998. I opened up my own firm in 98. I think that's about the same time he had moved back to his firm. And it was a bigger firm with resources that I didn't have starting out on my own, and so we started working cases together and worked a lot together.
Tell me, for the record, how that works when you're in a different firm than the firm he was in, correct?
Yes.
And so when two lawyers from different firms, or three, however many it is, share a case, how do you handle the payment of the fees if there's a successful recovery?
Well, it really all depends on the agreement that's reached up front between the lawyers and with the client's consent. But generally, all the cases that I work with his firm and with most firms I do business with, it's a 50-50 split on the fee recovery, or at least an equal split. Maybe if there are more than two lawyers, it'll be an equal split across the board. But generally, it was just my firm and his firm with a 50-50 split on attorney's fees recovered, and each firm recovers whatever costs they've advanced in the case. And sometimes his firm would advance more of the cost because they had a larger number of lawyers bringing in more money than I was and could afford to handle some of the bigger costs. But it's kind of whoever got the bill paid the bill, and then we reimbursed at the end whoever had advanced the cost.
Okay.
The client signs off on all of that.
Who ultimately, in those situations where is splitting a fee, is that a good way to call it?
Yes, sir.
Who handles the ultimate disbursement? How does that work?
whichever lawyer receives the settlement checks or the checks to pay whatever verdict or judgment that was received. I can't say in every single case with Alex Firm, but in having gone back through my files and audited my paperwork, it looks like in almost every single case that we worked together, the disbursement, the money would come through to me and I would handle the disbursement. They were generally clients where I would associate his firm. They were my clients. They were people that had come to me, and I wanted them to, frankly, know that I was the person that took care of them, and if they needed anything, they could come back. And so I wanted to be the person handling that part of it also.
All right, so if the money comes through you, then just mechanically, how do you go about paying Alec in a case where y'all are splitting a fee, or paying the firm?
Money comes in. Client has to come sign the check or whatever it is, along with my firm if it's made payable. It's generally made payable to Wilson Law Group or Wilson Law Firm and the client. Client comes in and signs the check. I endorse the check. We deposit that into my trust account. If it has to sit under Supreme Court rules, sometimes it has to sit for 10 days or more. Some smaller checks don't. Once it's been in the account long enough to be able to be dispersed pursuant to our rules, then my bookkeeper does the checks that I instruct her to do, and I sign the checks to make disbursements. If they're checks to another law firm, then the money is dispersed to that firm.
All right. In the course of litigation, are there typically costs and expenses that accrue during the course of that litigation?
Almost always.
And do those typically get paid out of whatever settlement is reached, assuming a successful result?
They do. All of my fee agreements and every lawyer I've ever worked with have a provision in there that the client understands that the fees are advanced by the lawyer, but upon recovery they're reimbursed or recovered by the lawyer.
In a particular case where you're splitting a fee and there were in fact fees and costs associated with a successful recovery, costs and expenses associated with a successful recovery, are those issued in a separate check typically, or a check together?
When I first started, I think my firm was doing cost and fees, not just for other firms, but cost and fees that were payable to my firm in the same check. But I mean, 10 plus years ago, if not longer, we started doing separate checks just to make the accounting and keeping up with it easier. So generally it's a fee check and a separate cost check.
And in 2020 and 2021, were you issuing those separate checks?
Yes.
Very quickly, without getting into the details, did you have a case in Allendale where you split it with Alec in the early part of 2021?
Yes, sir.
All right. And ultimately, was there a recovery in that case?
There was.
And
it was actually 3 cases, but they were similar factually, and so we treated them as one case, but it was three separate plaintiffs, 3 separate cases.
And ultimately, did your office disperse the fees and the expense check to PMPED?
On all 3 cases, yes, sir.
And those checks were made out to what when you dispersed those?
All 3 of the fee checks were made payable to, I don't know if we used the acronym PMPED or if we actually spelled out Peters, Murdaugh, Parker, Dietrich, and Ellsworth, but PMPED.
And generally, except for the Ferris case, which we'll talk about in a minute,
sure.
When you had those fee splits with Alec, were the checks made out to PMPED?
Yes,
They
sir.
were signed by you?
Yes, sir. And I'm the only person who can sign checks in my office. So, well, and now I had a partner at one time, but now I'm the only person that can sign checks.
Did you have a case involving Mack Trucks that involved Alec?
Yes, sir.
And can you describe to the court how you ended up getting that case and how you ultimately associated Alec in that case, please?
Sure. And I've heard it referred to as the Ferris case, so Mack Trucks and Ferris. I'd rather refer to it as the Mack Trucks case. Another lawyer had contacted me about a case that he was working on. Felt like he had a wreck involving a tractor trailer and an automobile in which a gentleman was injured. I believe he had already filed suit against the tractor trailer company and its driver and maybe another party. Started looking at the case for and with him. It involved a drive shaft that had fallen out of a Mack truck into the interstate, and this gentleman had, and a number of other cars had hit that drive shaft. And in looking at it and doing a little bit of research, I and he together realized that there very likely could be a products liability case involving a defect with the drive shaft of the truck or something like that. So, so I reached out to Alec and asked him if he could get involved in the case or would get involved in the case. I mean, that's what his firm specialized in a lot, was products liability cases. And we were pushing some deadlines to bring in all the parties that we needed to, and so I reached out pretty quickly because I knew we needed some help.
And did he agree to be part of that case?
He did.
As that litigation proceeded, did y'all have, as is typical, some discovery hearings, discovery motions, and that sort of thing?
Well, we had a number of them. I don't remember how many, but we had a number of different motions and discovery that went back and forth, documents being exchanged, things like that.
All right. And did that ultimately set up the prospect of a trial in that case?
It did, but it was unusual. It wasn't a jury trial like is normally done in personal injury cases. It was a non-jury trial tried before a circuit court judge with an admission of liability. We waived punitive damages, and there was an agreement between the parties that neither party would appeal the result.
And in a case, plaintiff's case, civil plaintiff's case like this, if there's a large recovery, let's say for the plaintiff, and the defendant decides to appeal, does that typically delay payment of the recovery until that appeal is heard and resolved?
I mean, it can. Appeals, you never know how long an appeal is going to take, and so if the losing party, the defendant, the company that you're suing, whoever it might be, decides to appeal, they can tie the verdict up for a while. If you win the appeal, you're going to recover cost and interest, so you know, that's the remedy, but it can tie up money for people that are injured that need that money.
Did y'all ultimately try that case in a bench trial?
We did.
What county was it?
Excuse me?
What county?
It was in Richland County, Columbia.
And when did y'all try that case?
The first part of January of 2021.
And who did the closing argument in that case?
Alec.
Alec did. Did y'all ultimately, there had been a concession of liability, so the amount was really what was in question. Is that correct?
Yes, sir.
And how many plaintiffs did you have?
There were actually two cases, when we call it Ferris or the Mack Trucks case throughout all of this, but there were actually two cases. The gentleman that was injured and then his wife, we brought a loss of consortium claim for her for the loss of companion services that she had lost from him. And just not to get too detailed, Mr. Ward, that her case had gone into default. In other words, Mack Trucks hadn't answered the papers like they should have. And so they were in a really bad position on that case. And in the gentleman's case, they had answered, but we were discovering some things. When we were doing some discovery, it was clear they didn't want us looking much, much further. And so that's why this deal, everybody agreed to a non-jury trial without appeal with a waiver of punitive damages and an admission of liability was done. And we were in COVID, and it was going to take us a while to get the trial. So it worked out well for both parties, and the result worked out well for us.
And that's often how it goes in litigation. Both sides kind of decide what's best, and sometimes they can have a meeting of the minds.
Yes, sir.
All right. Was there ultimately a verdict by the judge in that case?
Well, two verdicts since two cases, yes, sir.
And what were those amounts?
I believe it was $4 million for the injured man and 1.5 for the wife. I remember it was 5.5 combined, but I think it was 4 and 1.5.
And so how did the fees break down, to the best of your recollection, that were going to be split among the three lawyers involved?
There were
let me ask you this. Do you remember how much Alex shared of the fee?
$792,000.
Okay. And yours?
There was a larger split to the attorney that initiated the case, but I believe Alec was $792. The math didn't work out perfectly. I was $791. And the other attorney was higher than that, but I don't remember the exact numbers.
In recognition of his origination?
Yes, sir.
In March of 2021, did you ultimately receive the monies and prepare for disbursement?
Yes, sir. I believe they came in late February because we dispersed in March, and I had to wait at least 10 days. Part of the money came by a wire, which would have been kind of immediately available and accessible, but it was a smaller portion of the money. The larger portion came in a check. And because it was such a sizable amount, I waited maybe 12 or 15 days or so. I didn't disperse on the 10th day.
And did you have a conversation with the defendant about dispersing those fees?
I had a conversation with Alec and with the other attorney I worked on the case with when the fees were ready to be dispersed.
What about your specific conversation with Alec? Did he make any requests of you or have any discussion with you about how to handle his $792,000 share of the fees?
He did.
And tell me about that conversation, please.
When I contacted him and told him we were getting ready to disperse and we would have checks ready, he indicated to me that he was looking to place his fees in an annuity. He called it like a structure. I've never done one of those before, so I didn't really know how it worked. I've never done structure for my fees myself. I've structured client money, but not my fees. He indicated he was looking to do a structure by putting the monies into annuities, and that the checks needed to be made payable directly to him, that he had already cleared it with his firm, that the monies were going to be put on the books and accounted for, and he would be credited as having received those monies.
Based on his representations to you that he had cleared it with his firm, did you agree to do something different and make the checks directly out to him?
I did.
Quickly, what's been marked as Exhibit 345, states 345 for purposes of this in-camera hearing, and see if you recognize that particular document.
I do.
All right, and what is that?
So this is the initial check that was written per Alex instructions directly to him on the gentleman's case for fees made payable to Richard Alexander Murdaugh, Esquire, for $600,000. It's voided.
And why was it voided?
Because he instructed me afterwards, and I don't remember if it was in the same conversation or shortly thereafter. It must have been shortly thereafter, that the checks on that case needed to be made in 2 separate check payments. He was doing 2 separate annuities.
Show you what's been marked as 346 for purposes of this in-camera hearing, and see if you recognize these documents.
Yes, sir. The first page is the check payable directly to Richard Alexander Murdaugh, Esquire, for $192,000, and that is on the loss of consortium case for the wife. And on the bottom, just like that $600,000 check that was voided, it indicates it was for fees. I guess the other writing on here is maybe from my
I'm just
the
focused
checks.
on the checks.
It's something to do with the way we recovered the checks.
All right.
The back page looks like an endorsement. Pay Bank of America deposit only. Looks like a signature, Bank of America.
Okay. And again, I'm just asking you to see if you recognize those checks.
Yes, I do.
Yeah.
I recognize
All right, tell me the second check, just the amount and what that's for.
The second check is for $225,000 payable directly to Richard Alexander Murdaugh, Esquire. It indicates on the bottom that it's for fees. This would be part of the rewrite of that $600,000 check that had been voided.
All right.
And then the third check is $375,000 check payable directly to Richard Alexander Murdaugh, Esquire. and it indicates fees, and that would be the remainder of the rewrite of that $600,000 check initially written that was voided.
And those second two were rewritten, why?
At Alex's request, he had indicated that he was putting the money into two different vehicles or annuities and needed the checks written that way.
All right. What did you do with those checks after you, the 3 checks after you had finally cut them?
Obviously, I signed them, and at some point in time, I think Alex sent somebody up to my office to pick them up. I don't think I delivered them. Oftentimes, I put checks in the mail. Sometimes when they're larger, I either offer to have them picked up or delivered, and I think he had somebody come pick those up from my office.
Like a law firm runner or somebody like that?
Something like that, yes, sir. I don't even think I was in the office when they picked it up.
You've known Alex for a long time, right?
Since they're since the mid-'80s, mid-'80s, yes, sir.
Worked with him for a long time?
Many times.
Did his explanation to you about what he was going to do, did that raise any suspicions with you, to your friend that you've known for such a long time?
No, sir. It was different, but it didn't raise any red flags or suspicions to me that anything wrong was going on.
Because you trusted your friend, right?
Very much.
What was your perception of Alex's general wealth and success?
Thought he made a lot more money than I did. Always seemed to do well in his practice. All I ever heard is that he was one of the biggest producers in the firm. It's his family's name on the firm, but they acted like it was his name on the firm too. He and I handled big cases together. When I talked to the partners and other members of that firm, they were talking about big cases that they were handling with him. Felt like he did really well. We never got into direct discussions about the amount of money he made or the amount of money I made. We talked about, sometimes business and sometimes money and sometimes things, but I always thought he made a lot of money.
Is that part of the reason why your suspicions didn't arise when you were asked to do this request by Alec?
I guess so. Not so much as just I'd never had any dealings with him that I'd had any reason to distrust what he was telling me. I mean, he was a partner in that firm. He had the authority, as far as I knew, to make decisions. If he'd have wanted to reduce the fee and take less, and it was payable to the firm, I wouldn't have questioned that. I didn't feel like he had to have his authority, his partner's approvals to make those type decisions.
All right, I'm going to show you what's been marked as 347 and see if you recognize that document.
Yes, sir. The first check is a check that was made in May of 2021, May 13th, to Peters, Parker, Murdaugh, Ellsroth, and Dietrich for $14,619.13. I don't think on the bottom it says anything, but this was a cost reimbursement check on one of those two cases. And then the second check is a check made payable on the same day, May 13th, for the same amount of money plus 1 cent, so for 14 cents. And it was a cost reimbursement in the other case.
All right.
And that's made payable to the law firm also.
Who was your assistant or paralegal at this point in time?
Vicky. I mean, she's one of several, but Vicky is my primary paralegal.
At some point in May of 2021, did Vicky advise you of any inquiry coming from PMPED about where these fees were?
No, she didn't advise me in May about any inquiry about where the fees were. She had received an email in May from Alex Paralegal, Annette, that said, hey, we got the cost check, but we don't have the fees. Where are the fees? And she replied to that email to Annette and said, your boss has already been paid the fees just like mine and the other lawyer. Vicky replied to that email. I didn't know about that email until all of this came out in September of what was going on. I didn't know about that reply email to Annette. Vicky did receive another email from Annette, and as I recall, it was an email that Annette had received from Jeannie Seckinger that Vicky did forward to me sometime towards the end of May. I think she had gotten it, but she was out on vacation for a couple of days, and when she got back, she forwarded it to me. And it was an email from Jeannie Seckinger that said something to the effect of, Alex thought he was owed more cost in the case, had some questions about cost, and they were trying to get some information so they could determine if they were owed more cost. She did forward me that email.
I'm going to show you what's been marked as 348 for the purposes of this hearing, states 348, and see if you recognize that document.
Yes, sir. This looks like the email string where Jeannie Seckinger, the Chief Financial Officer at PMPED, emailed Annette Griswold, which was Alex's primary paralegal, basically says that Nicole, I don't even know who that is, brought them the expense check and that didn't match their records. Alex thinks he has more outstanding cost, but can't say what, and they want to see if they can get some information concerning expenses and disbursements. Looks like Annette forwarded that to my paralegal, Vicky, on May the 27th. Vicky was out. Looks like Annette asked her again on June the 2nd if she could get her some information, and Vicky replied to Annette that she didn't deal with some of the documentation they were requesting, and so she would forward it to me.
And what? That's June the 2nd. When?
2021, June 2nd.
June 2nd, 2021.
Yes, sir.
At this point in time, are Alex fees still in your trust account?
No, sir. They were dispersed. The check is March. I don't know the exact date, but they were dispersed in 3 separate checks in March.
Okay. At some point in time around this June 2nd, thereabouts, did you receive any call from Lee Cope?
I believe I had a conversation with Lee Cope. I was trying a case in Hampton the week before that, and I was in and out of their office, and I believe I had a conversation with Lee. That would have been like the week of May the 24th or some of those days in there, and I believe I had a conversation with Lee. He asked me if all the money had been dispersed in the Ferris case, and I told him that it had not been, that we had some liens outstanding, medical bills and liens outstanding, and we were holding money for some additional costs in case things came in, and he didn't ask me any further questions. He did not mention that there were any issues or concerns about fees.
After you received that call from Lee Cope, well, what did you tell Lee Cope?
I told him I'd have to check into it.
After that, did you reach out to the defendant?
I did.
And what was your conversation with him?
I reached out to Alec and I said, Alec, hey, I don't know what all we talked about in that call, but at some point in time we talked about, I said, hey, I've got this email that's been forwarded to me by Vicky where your firm is saying that you believe you're owed more cost. I put the cost down on the disbursement sheet that you had given me. But if you've got more cost, just figure out what it is and get it to me. We're holding some money to deal with some medical bills and liens. And with the client's consent, we were holding some money in case additional costs come in. Sometimes costs are slow coming in, and that's normal. And if there's an issue, just let me know. He said, I'll check on it, or there's not an issue, or I'll check on it. And I said, hey, this is the case that I disperse the fees to you, per your request. is everything all right? And he said, yeah, I just got to make sure they know it's on the books the right way and that this is the case that we've already worked out, the put it on the books.
Did he tell you he had structured those fees and annuities as he had told you before?
Yeah, that he had put them in the annuities.
Put them in the annuities. Firm's going to make sure they're on the books.
As far as I knew, the firm was aware that the monies had been paid to him, that he was putting them into annuities, that they would credit him as already having been paid, and they would account for that whenever or however they split up money.
Just to be clear, those funds were not in your trust account. They were gone at that point.
Yes, sir. They've been gone since March or whenever those checks were cashed after I wrote them in March.
$792,000.
Yes, sir.
For purposes of this hearing, I'm not going to go into the night when Maggie and Paul were killed, but just very quickly, you did have some texts and calls with Alec that night. Is that correct?
Yes, sir.
And you were at the residence and responding as friends and family did in the aftermath of that event. Is that correct?
Yes, sir.
After a few weeks after the murders, did you
I've got one. I got one.
You good? Take a second.
Fine.
You good?
Fine. Yes, sir. I'm fine.
A few weeks after the murders, did you have another conversation with Alec asking him if everything had been handled with the firm and those fees?
Yes, sir. I don't remember if it was 2 weeks or 3 weeks or what it was. I mean, everybody was destroyed. I don't think anybody was focusing on that. I know I wasn't, but at some point in time after that, I just said, hey, is everything all right with the, contact I got him with those fees? And he said it was.
At some point in mid-July 2021, over a month after the murders, did Alec call you up and ask you anything about these fees?
He did.
Tell me what the conversation with Alec was about these fees.
He contacted me and said that he was not able to structure the fees the way that he thought he was going to be able to do, that he had messed that up, and that the fees needed to be paid to the firm, and they needed to go back through my trust account.
Okay. And what did you say at that point?
I didn't see anything that caused me any red flags or anything, and felt like if that's what had to be done, that the fees had to be paid to his firm and needed to go back through my trust account. He could send me the money, and I could run it back through my trust account and then pay it to his firm.
So he's promising, he's saying, I will send you the money back. Is that correct?
Yes, sir.
Did you ultimately receive any funds?
600,000 of the 792.
You only received 600,000?
Yes, sir.
And how did you receive that? Do you recall?
I think it came in two different wires, that either came on the same day or on back-to-back days.
Did one of those wires come from Palmetto State Bank for $350,000?
I believe so, yes, sir.
And that was on or about July 15th?
That sounds right, yes, sir.
And the other was about $250,000 on July 16th, 2021?
I believe from Bank of America, yes, sir.
That was only $600,000?
Yes, sir.
So you're short from what you'd already given to Alec, correct?
Yes, sir.
How much are you short?
$192,000.
$192,000.
Yes, sir.
Did you have a conversation with Alec about being short?
I did.
And what was your conversation with Alec?
He told me that he wasn't able to access the $192,000 immediately, that he had already put it into the annuity, but he couldn't do it the way he wanted to, but he couldn't access it because it would be penalized if it was withdrawn, and that he would get me the money.
So what did you do in response to what your friend told you to do, or told you about the reason why he was short $192,000?
I mean, at that point, I had an indication that I was supposed to have $792,000 in my trust account that was supposed to have been paid to his firm. I'm responsible for that trust account. I put $192,000 of my own money in that trust account to cover the shortfall.
Based on his representation that he'd get you back?
Yes, sir.
going to show you what's been marked as Exhibit 349, states 349 for this in-camera hearing, and do you recognize that?
I do.
Tell me what that is, please.
This is an email that I sent to Alec at his request. He said he needed to be able to provide it to his firm so they'd know the money was being held, and it was dated July 19th of 2021. It says, Alec, as discussed, I'm confirming that I'm holding in trust $600,000 in the gentleman's case and $192,000 in the lady's case, which represent attorney's fees. I'll continue to hold these monies in trust until I am instructed by you or your firm regarding payment.
You sent that email at that point in time. Did you receive any further inquiry at that point in time, at least, from the law firm saying, all right, go ahead and send us the 792?
Mr. Waters, I didn't hear anything else from the law firm at all until September the 3rd, 2021, about 3 o'clock in the afternoon, when Mr. Lee Cope called me. The first question he asked me was, why was I still holding $792,000 in my firm? That seemed to be his first concern, and I said, yes, I am. And he said, well, we need to get that money paid to us. And then he told me that they had discovered a check that I think I remember him telling me that was from me to Alec in the firm, and that they had discovered that Alec was stealing money from the firm and from clients, and that he could not talk very long, and asked me not to say anything to anybody until the following Tuesday when they could issue a press release.
Let me slow you down just real quick before we get there. At some point in time in August, did you attend any event or any conference where you saw Alec?
I did.
And what was that?
It's called South Carolina Association of Justice now. I still call it the Trial Lawyers Association. We have an annual convention in Hilton Head every August, the first weekend, and I usually attend and was there. And Alec was there.
Did you see Alec there?
I did.
And did you have any conversation with him at that conference about the $192,000 that you covered for him when he was going to pay that back?
I believe I asked him about it, and he indicated he was working on it. Some discussion about his father's estate. His father had just passed, and there would be money coming from the estate, and then with Maggie's estate being tied up, also.
Did he say he might sell some property or something like that?
I think he did mention that he was working towards selling some property.
At this point in time, still with a couple of months after the tragic murders of Maggie and Paul, were you still very sensitive to your friend's emotional health and well-being?
Sure. I didn't push him.
Didn't push it?
No, sir.
Some point after that conference where you asked him about it, didn't want to push him, did you have another conversation with him about when that money might be paid?
I believe I did, yes, sir.
All right, I'm going to show you what's been marked as states 350 for this hearing. See if you recognize that.
I do.
Tell me what that is.
It is a very rudimentary, handwritten, scratched-out promissory note that I asked Alec to sign for me, which he did August 17th of 2021. Acknowledging that I had loaned him $192,000 that he would repay within 60 days, I think is what it says.
And tell me how the circumstances of how you came to get this, essentially on a folded piece of paper. This is a copy of it, right?
It is, yes, sir.
All right, tell me about it, please.
That was more about, I wanted to get repaid my money as quickly as possible, but that was more about, I was concerned, just like everybody else, everybody in his firm and everybody in his family, that he was going to do something to himself, that he was going to kill himself. And I knew enough to know that that I couldn't make a claim against his estate if there wasn't something in writing. And so that was more, I went to him and said, Alec, look, I hate to even ask this, but I need to ask you to do this in case something happens to you. And I phrased it like if you get hit by a car or something, but it was It was more about worried about what he might do. And I need to ask you to do this so that if there's a problem, I can deal with it. And he did. He didn't have a problem with it.
You already said this part, but at some point a few weeks later, you get a call from Lee Cope asking about those fees and saying that Alec had been stealing money, right?
Yes, sir.
That hit you like a thunderbolt?
It knocked me down. I mean, I was with a group of guys. I could not talk. Lee told me he could not talk very long. I didn't know how to react.
Did you try to get in touch with Alec?
I did. I mean, I couldn't do it immediately. I think I spoke to Lee for just a minute. He told me I needed to call him right back. I called him back. We talked for just a minute. He couldn't talk long. He said he had other things to take care of to deal with all of what was going on.
Do you remember what day this is?
September 3rd, Friday, 3 o'clock in the afternoon.
2021?
2021. Yes, sir.
You remember it like it was yesterday?
I'll tell you exactly where I was and who I was with.
Tell me more about what happened.
I finished up what I was doing with that group. I think I tried to call Alec, or I know I texted him. And I believe I tried to call also, and I couldn't get him.
Okay. Did you continue to try to contact him?
I did. I think he did respond maybe that afternoon later and said, I forget what it was. It was in a meeting or something. I'll call you back as soon as I can. But at some point in time, I kept trying to get him, and we did talk later.
All right. What did you talk about? What day was that when you finally were able to talk to him?
I think I did speak to him that evening, this Friday, September the 3rd, by phone. I don't remember the exact of the conversation, but I said, look, Lee's called me and told me what's going on. What is going on? He said, I really can't talk about it much right now. I said, I need to talk to you, and I want it to be in person. I need to know what's going on. And
what happened next?
Well, he said he would try to meet with me the next morning, and that he was sorry. And I don't remember all the gist of that conversation, but the next morning I tried to call him. I woke up and I started driving towards Beaufort because I thought he was staying at John Marvin's house down that way, and I started calling him and driving his direction. And eventually he called me back and said he would meet me in Alameda at his mom and daddy's house.
Did you meet him there?
I did.
Was that in the morning of September 4th? Probably
Probably a little bit before lunchtime, kind of late morning, yes, sir.
Did y'all have a conversation?
We did.
Where was the conversation?
I got there before he did. I don't think I pulled in the driveway. I kind of waited out on the road. Pulled in the driveway. We went in the side door. The caregiver was there. We went out onto the front porch, and we talked on the front porch.
And what did he say to you?
I mean, the first thing I asked him was, Alec, what the F or what the H is going on here? What is going on? And have you done something else to me or that involves me that I don't know about? Because I know about this, and I've got to deal with this. But is there something else you've done that I don't know about that I need to be concerned with?
And what did he say?
He broke down crying. Said I can't right this second. He went inside, came back out with some paper towels, and told me that he had a drug problem, that he was addicted to opioids, and that he had been addicted for, I don't remember if he said 20 or 20 plus years, but for 20 years or so.
Did he say anything about the money?
He told me that he had been stealing money.
Did he have a particular phrase about what he had done to you?
Shit me up.
He said he shit you up?
Shit me up or shit me off or something like that, but I think it was he'd shit me up.
And he said that he admitted to you he had been stealing client money?
Yes, sir.
So he confessed that to you, is that
He
correct?
said he had shit a lot of people up.
I'm going to show you what's been marked as States 313 in this in-camera hearing. Do you recognize that?
Yes, sir.
What is that?
I think this is the original of that $225,000 fee check written in the gentleman's case directly to Richard Alexander Murdaugh, Esquire.
Is that your signature on it?
It is.
conversation end?
I don't remember exactly how it ended, Mr. Waters. I was so mad. I mean, I'd loved the guy for so long. And I probably still loved him a little bit, but I was so mad. And I don't remember how it ended. I left. I mean, I asked him, how did I not know these things or see these things, and we talked. He was concerned about me getting my $192,000 back. Seemed concerned. Told him I wasn't worried about that. At that point, I wanted to make sure there wasn't something else.
Just a little bit before lunch on September 4th.
Yes, sir.
We
didn't leave. We didn't. I'm sure I yelled at the beginning, or at least raised my voice, but I didn't leave yelling and screaming and hollering. We didn't fight. But I left. I wasn't happy.
Where'd you go after you left? Do you remember?
I rode through Hampton. Actually, we threw Hardee's and grabbed something for a bite of lunch on the road and headed back to Columbia where I live.
That day, did you hear anything else about Alec?
I did.
About how long after you left Alec did you hear something?
I had stopped in my office in Bamberg or at the post office to pick something up, and I was somewhere between Bamberg and Columbia when I got a call. It was either from Randy or Lee Cope, but I believe it was Lee Cope.
And what were you informed?
That Alec had been shot in the head and that he was on a helicopter going to the hospital in Savannah. And I think it was Savannah Hospital, but they said the hospital, but I believe they said Savannah Hospital.
What'd you do in response to that information?
What the devil's going on? I thought he'd tried to kill himself. I didn't think he was suicidal when I left, but when I heard that, I thought he'd tried to kill himself.
Did you go to the scene, or did you return back home?
I went back home.
Did you try to reach out to Alec after that?
I did not. I talked to his brother Randy, I think some that same day and some on the next day. But by that time, frankly, all this had, for lack of a better term, blown up to where I didn't think I'd be able to talk to Alec. And I don't know that I wanted to.
Have you had a conversation with him since?
I have not spoken to him since that morning at Alameda.
Have you had any other communication with him?
He's texted me once or twice, to which I've responded something very generic, like I'm thinking about your family. And I think he may have written a letter, some short letter that, frankly, I turned over to my lawyers.
I'm going to show you what's been marked as States 351. See if you recognize that.
I do.
And what is that?
This is one of the texts that I received from Alec and my response.
Is that a number you previously had recognized being Alex?
I don't know if I'd ever seen that number before, but it's not the normal cell phone number that I would have used to contact him or he to contact me. I mean, sometimes he'd tell me he was calling me from the phone in his car. Sometimes it would be a number I didn't recognize.
Screen there.
Yes, sir.
Does it say, "So sorry for all the havoc I created for you. I'd do anything to make it right"?
Yes, sir.
Thank you, Mr. Wilson. That's all the questions for this in-camera hearing, Your Honor.
By the defense.
We have no questions, Your Honor.
All right, Mr. Wilson. Take care. How many more witnesses do you anticipate on this matter?
There's there's a lot of moving parts, Your Honor. I do have a law firm witness that I would like to call on this particular matter, one of the partners. We have the Satterfield matter. There is a confession of judgment, but we can present testimony on that as well. And we have a bank witness to establish the financial condition of Alec at the time these murders happened, which was he was burning through cash like crazy. He was out of options. The $792,000 was gone in no time at all. And I think the evidence is very compelling that for an extended period of time he had been living in a velocity of money that is really quite stunning, and he constantly had to achieve more money to avoid the reckoning that was happening. I'm sorry, Mr. And so it will show on that particular day that on June 7th, 2021, when he's being asked about these fares fees, the financial condition is not good. There's not that money there. He's extremely leveraged in the debt that he has, and it will be part of a history where he is forced to do all these things that we've been showing through Ms. Seckinger to stay afloat and to stay one step ahead. And for the jury to understand the reality of what he was facing, they have to understand the extent of what is being potentially exposed. They have to understand why he would be doing these things and why he was out of time. This is not the kind of case where, and I don't know if you want a legal argument at this point, but...
well, I asked the question.
Yes, sir.
I guess this is still your answer. I don't know.
Yes, sir. Thank you. Thank you, Judge. So anyway, this is the kind of case where, for example, he mentions the Boat case out of the gate. The Boat case, the hearing was going to be that week. We will establish evidence that the hearing was to get access or get identification of his accounts. Once that happens, that he would be unable, there would be not long before what had been going on would be exposed. And what we're talking about, and this is really how it's different from some of the other res geste and other cases that you're looking at, is it's really about the fear of what is about to be exposed. And what we're talking about, again, is a decade of malfeasance and misappropriation that ultimately would result in the charges that it's resulted in, as well as loss of his livelihood and loss of his law degree. And that's the real fear that was there. And when we look at June 7th in particular, at that point in time, he's out of options. We've heard from Ms. Seckinger that in the past, if he'd been able to pay that money or repay that money, then he could always kick that can down the road. But on this particular day, the state believes we have evidence, and we believe it's a reasonable inference from those evidence that he was out of options. But for the jury to really understand what's going on, they have to understand the full picture of what this man has been doing and what he's been trying to hide. And frankly, what he was able to successfully hide in the wake of these murders. The bank witnesses will also establish, relevant specifically to this particular witness and the events that you've heard about, is that one of the first things that Mr. Murdaugh did, business-related, was to secure $600,000. He got a loan from PSB, Palmetto State Banks, that wasn't even on the books. They just wired the money. Russell Lafitte wired the money, $350. He borrowed $250,000 from another person, and that's the $600 that he gave to Chris, that he used to talk Chris into telling PMPED that all $792 were back in the account. And so again, that's one of the first things he did to stave off the inquiry that very morning, 6/7/21, was to get that money in there, and it did. It staved off the inquiry. The fact that Ms. Seckinger, there had been a number of things that had been occurring over a while, ultimately turned her attention back to Alec. It doesn't change the fact that it did effectively delay that time period and delay the ultimate detection of that. And he was able to put that money in, much as he was able to do when he stole the $125,000 from his brother, or he used the firm credit card, or what we see throughout this, throughout the extent of his financial matters. So the bank witness ultimately will establish two things. Number one, his financial condition at the time, and number two, his efforts in the wake of the murders to secure that additional money so that he could get enough back to Chris Wilson to talk him into telling the law firm that there was nothing to see here, that everything was okay. And frankly, it worked until two things happened. Number one, Ms. Sechinger started to look back at the Hirschberg matter, and then more importantly, and we have another law firm witness. I don't know the check's up on the screen. Stand by for me, Your Honor. That found this check right here, this very one, in his office right around that same time in early September. And at that point in time, they knew that he had been lying to them about these particular fees. And that's what caused everything to unravel. And then, just like we see, Your Honor, with what happened on June 7th, 2021, within a short period of time, the side of the road happens. And Alec immediately claims that he was the victim of a horrible attack, and everyone immediately assumes that the bad guys are back. There's a symmetry, Your Honor, between what happens on the side of the road and what happens on June 7th, because when the hounds are at the door, when Hannibal's at the gates for Alex Murdaugh, violence happens. And the same thing happened on the side of the road that happened on June 7th. And for this jury to understand the real picture of this man, that I will remind Your Honor, I know you're well aware of, that they have already repeatedly put into issue his character and what a loving father he was and all the rest of it. They need to understand really what this man was hiding. And he was hiding something we have never seen before. And the pressures of that are important for the jury to understand why this man might do that.
Mr. Griffin, any comments you'd like to make?
Yes, Your Honor, I would like to respond. What you've heard thus far today does not establish that Hannibal's at the gate in any form or fashion. What you heard from Ms. Sechinger, is that what's the language she used? Hang on, I've got it right here. Quote, there's a history of trust and brotherhood in that firm, and that some similar events have happened in the past where Alec had been overdrawn with the firm through loan checks or expense checks, and that eventually the money gets paid back and everyone goes about their merry way. I mean that is basically what she testified to, Your Honor, and this sort of concept that Alec committed murders to cause a delay in the firm investigating this diversion of fees was debunked by her own testimony, where she said, number one, Mr. Randolph Murdaugh was going back in the hospital to die, and that I stopped in my tracks and I became a friend and stopped looking, and that Mr. Murdaugh did die. I mean, that's what stopped her conversation, and that's what stopped her inquiry on June the 7th, by her own testimony. And then you go forward, and then she says she passed it off to Lee Cope. And then Lee Cope kept following up, and he communicated with Mr. Wilson. And Mr. Wilson sent an email. Alec had gotten money back into the account. And frankly, Your Honor, if this plays out, as we attach to our response, the draft transcript from the trial testimony in Russell Lafitte's case, that Mr. Murdaugh had in progress at Palmetto State Bank a loan application to get refinancing, and that Maggie's murder stopped and delayed that. And it had the complete opposite effect. He wasn't at the end of his rope. The murder of Maggie, if we have to play out this, the murder of Maggie actually caused a delay in the refinancing of the Edisto house, and it precluded getting additional loans from Moselle. And so those are the facts. And how murdering Maggie Murdaugh and murdering Paul Murdaugh eased his financial stress, it didn't. There's no financial gain, as we said. There's no life insurance. There's nothing to be gained by it. And so there's no logical connection from his, disastrous financial house and potentially having to be answer to financial misconduct within the firm, losing his law license, being criminally prosecuted. And it's all just a theory. There's no facts. It's all just a theory. But their theory is the best way out is for him to murder his wife and son and put himself bullseye in that circle that you heard about in the testimony of this case, and that he is the prime suspect number one because he's the father, he's the husband, he finds the bodies, they show up and he's holding a shotgun, and he does that to get out from under scrutiny of a $700,000 diversion of fees with a history of trust and brotherhood in that law firm. Your Honor, there is no logical connection whatsoever, and it does not lead to evidence of motive. And we can have more testimony, but frankly, Your Honor, it doesn't meet. And then if we go into 403 and unfair prejudice, you heard a lot of unfair prejudice here, but the undue delay, confusion of the issues to the jury, they've got a whole lot more evidence about financial misconduct than they have about a murder and evidence of guilt in the murder case. And that's what this is all about.
With regard to the list of other witnesses that Mr. Waters indicates that the state has, for purposes of the court being able to do an analysis as to whether there's clear and convincing evidence, you have indicated with regard to some of the witnesses, some of the files, you do not or did not contest them. But if you have a few employees from the law firm, including Lee Cope, Mr. Murdaugh's secretary or administrative assistant, excluding someone from the bank. Who's the other person you mentioned?
Well, we have also the Satterfield, which of course we have a confession of judgment for purposes of this hearing, that might be sufficient for the court's analysis, although the circumstances I think are very relevant. And then with the boat case, the one thing I want to add, and that would be Mark Tinsley in the boat case, is to understand the context of the boat case and understand how this all relates to everything, is not only was the discovery there being sought by Mr. Tinsley, but there will be testimony. And again, this is all in transcripts, which they have, and I don't know, I've talked with the defense about, obviously they don't have to concede and they'll be able to cross and all the rest of it, but it is in transcripts. They've had a chance to review it, whether or not that's sufficient, at least for an in-camera determination. But one of the things that Mark Tinsley will say was the very aggressive posture which they were taking in the boat case, which meant that Alex Murdaugh was not a defendant of convenience, that the goal of the litigation, at least as it related to him, was a personal recovery. And that is why he was proceeding so aggressively in that particular case. Mark Tinsley will also say that, and we'll talk about how that litigation was going, but we'll also say that after the crimes of June 7th, 2021, that landscape completely changed. This was an extremely significant liability, and the testimony will be that that aggressive posture, seeking a personal recovery from Alex Murdaugh, actually of $10 million, that they weren't coming off that, and that was the manner in which that litigation was going. Once the murders happened, that was done, and Mr. Tinsley will testify to that, at least the posture that they were taking.
Well, the court has heard sufficient amount of received sufficient amount of evidence to make a determination regarding clear and convincing evidence involving the law firm, and do not need to hear from Mr. Cope or the other witness, what's her name? Ms. Griswold, in order to make that determination of there being clear and convincing evidence. With regard to Satterfield, you do have a confession of judgment, which the court has not seen or reviewed. With regard to the boat case, there's been no testimony. In the record regarding the impact of that on Mr. Murdaugh's state of mind or the like. So Mr. Tinsley, particularly considering the representations by counsel that the plaintiffs in that case were just seeking a financial statement, basically. And so the court can hear from Mr. Tinsley, review the confession of judgment, then hear arguments from the parties once again regarding the admissibility of all of this as relates to these other bad acts, and also the limitation on this, if any.
Yes, sir. Two matters right now. I do have the confession of judgment, which I can mark, as well as the disbarment.
I don't believe the rules require a full-blown trial on these matters for the court to make a determination of clear and convincing evidence.
I do have two issues. It would be, of course, we have the bank witnesses to establish that financial condition, and there's that.
The bank witnesses also included. I overlooked mentioning the bank witness.
I do have and that we can definitely do that in the morning. I do have a problem, unfortunately, that Mr. Tinsley is not available in the morning, but can be here first thing Monday morning, Your Honor. But we can handle the bank witnesses in the morning.
All right.
And again, we do have a transcript. Is the transcript?
It's your case.
Yes, sir.
Your Honor, we have filed a separate motion with the court on the admissibility of essentially Mr. Tinsley's testimony for any consideration by the court, because he's giving, a legal opinion. It's a judicial decision. It's not Mr. Tinsley's decision, and we've submitted that to the court. So we don't think anything Mr. Tinsley has to say would be relevant. We'd be prepared to argue that tomorrow or tonight if you'd like.
Well, I haven't received that motion.
Here's a clocked-in copy.
When was it clocked in?
January 24th, 2023.
January 24th. Last Tuesday?
Long time.
When was that? Last Tuesday?
Seems like yesterday.
That was last week.
I did see that. I didn't realize that was pertaining to Mr. Tinsley.
Yes.
Well, we'll address Mr. Tinsley's issue when Mr. Tinsley is available. I cannot conclude based on argument that his testimony will only be relate to a question of law. So we'll defer anything, any presentation until Mr. Tinsley is available, and then we can press on with the other witnesses tomorrow morning before the jury gets here at 11:30. We'll start at 9:30. Hopefully that 2-hour window will be sufficient with a break in there somewhere. Regarding the Satterfield matter, what's the defense's position on that?
Your Honor, we agree that they have a confession of judgment. We agree that there's an order disbarring him for that conduct, and they concluded that confession of judgment, even though it it has a disclaimer. Anyway, the Supreme Court concluded that is an admission, so for purposes of disbarment, and I'd be hard pressed to argue against that satisfying clear and convincing standard. That's all.
And what year was that? The wrongful conduct.
Well, yeah, well, the Satterfield matter, I don't have it off the top of my head, but it was quite some time ago.
2019, 20, 29, no, 20.
Satterfield issue separately. Aside from the court determining just the issues in general regarding whether or not this testimony should be admitted on motive, identity, common scheme, res gestae, there's a separate issue regarding remoteness. And of course, I know the state believes that this is a thread that's woven through all of one thing to the other that culminates in the conduct on June 7th. We'll hear arguments on that later.
Your Honor, not to belabor the point, the additional ground would be consciousness of guilt, which is a basis for admissibility. And again, that's kind of what we're talking about. I mean, that goes under 404, but the case law is long. The consciousness of guilt is fear of detection is a basis for
you submitted something on that?
I'll get you some additional cases on that, Your Honor. We'll have that for you by tomorrow.
All right.
I'm not sure what act he is going under the consciousness of guilt prong to the extent it exists. I don't know what he's talking about.
I don't know either. We'll see.
Well, again, he's trying to avoid facing life without parole and the loss of his livelihood. And for the jury to understand that, it's more than just $792,000. It's this entire time period. And that is really the issue, is avoiding that detection.
Okay, well, we've done enough on this day. We'll resume at 9:30.